Thank you very much. This is day 2 of the SCAN appeal of the City of Snoqualmie final environmental impact statement related to the Snoqualmie Mill Ventures proposal for the Snoqualmie Mill site. We left off yesterday after hearing from 3 appellant witnesses. We agreed that this morning we would start with the next appellant witness. Before we begin with testimony, let me just have a quick show of hands, any procedural issues that we need to address before we dive in. Mr. Sturbank, you unmuted.
Yes, Ms. Examiner, a couple procedural issues. One, we wanted to circle back and inquire. I think you had started to rule on some pre-hearing motions yesterday, and I think the conversation got a bit sidetracked into the searchable version of the appeal and whether flooding was an issue. And I'm not sure that the examiner had an opportunity to provide a ruling on the question of whether or not reasonableness of alternatives is an issue in the appeal. It's not listed as a separate appeal issue in any way, and yet it featured prominently in the appellant's pre-hearing brief. And I think we both, the applicant and the city, raised that orally yesterday. And so I wanted to bring that issue up this morning.
Thank you. It's true. If that issue was raised, I did miss it. So I do need to circle back and look at that. I don't believe reasonableness of issues was addressed in the appeal, but I haven't scoured it for that.
So, Ms. Examiner, just we had a lot of items there in our procedural motion on this one. The word alternatives appears in the standing section. It appears in the request for relief section. It does not appear anywhere in the, it does not appear as a general claim in the allegations of error. In addition, there are no witnesses who are identified to testify on alternatives. So the issue may not come up during witness testimony. But since that claim did appear in the appellant's pre-hearing brief, we wanted to raise it.
Thank you. Let me hear from appellant's counsel on that. Do you want to respond?
Regarding the reasonable alternatives, it is included twice within the appellant's notice of appeal. It's not a separate section, but it is included. And I know we included in our pre-hearing brief regarding having somebody testify to it. That I guess we didn't identify a specific person, but I think the idea was that there might be some of the witnesses, maybe even the lay witnesses, who would just touch on that topic briefly. I don't know that needed to be a whole separate section.
Got it. So to be consistent with my pre-hearing ruling, that items need to be specifically identified as alleged errors with enough specificity to allow the parties to be apprised. I don't feel that the inclusion of the discussion or the mention of reasonable alternatives in the standing section and the request for relief section, which is the only 2 places I'm seeing it in the appealed letter, meets my standard that I have established for fact pleading. And so I didn't notice this issue before, and counsel raised it yesterday for the first time, and I did miss it in the wash of other information that we addressed procedurally yesterday. But to be consistent with my ruling, my pre-hearing ruling on the limitations on the scope of the appeal, it would be appropriate for that not to be included in the alleged errors. It's not actually a detailed alleged error. So I would agree with the applicant, or the city and the applicant, that it is not within the scope of the appeal. To the extent that witnesses have testimony that touches on that at all, if that testimony is offered, I expect we would have objections and that I would have to rule on those as to whether or not that conversation is relevant to anything else or not. So I agree with city and the applicant that it's not detailed adequately in the appeal letter to have perfected an appeal as to that issue. So I'm going to add that to the list I'm keeping of appeal issues that are expressly excluded. Sorry that got lost yesterday and that we're having to address that again today. Were there other things that I lost yesterday?
One other procedural item, Ms. Examiner, and that relates to Exhibit S19, which is a letter, and I think the examiner had started to address objections about that in scope, and again, that may have gotten a little bit lost in the prop wash of the other issues. With respect to that letter, it has a brief mention on page 3 related to water, and two mentions on page 7 of contamination. But otherwise, the letter, which I think is 9 pages in length, addresses many other issues that you've already directly excluded, including stormwater, flooding, and sewer, and other issues raised in the letter, those being rural character, cultural resources, liquefaction risk, are also clearly not within the scope of the appeal. And I think this raises the risk of, for lack of a better term, record pollution. If it's allowed in now, it risks being cited to later as if those items in the letter were somehow live appeal issues, even though they've been excluded or not raised. And so, and since the appellants are going to present 2 witnesses on the water and contamination issue, Mr. Hill and Mr. Jack, this morning, I think the city's request is to exclude the letter. The witnesses are going to testify to what they testify to, and that would avoid potential prejudice to the city and to the applicant down the road that could arise from admission of that letter.
Right. On that letter, I did expressly rule yesterday that I included S19 in the list of exhibits that were objected to. That includes 19, 25, 38, and 45 through 51 that will be stricken absent relevant testimony pertaining to the content of those documents. And that once I have heard the testimony of the 2 witnesses on the topic, if the city wants to renew its motion to strike that exhibit based on the fact that it's not needed based on their testimony, I would hear it again.
Thank you very much for the clarification.
Yep. Anything else that I missed in the
Nothing further from the city at this time.
Okay. Ms. Clinton, anything we need to address procedurally before we get started with testimony?
No.
Thank you. Ms. Courtney Kaler, nothing from you? No. Okay.
No, nothing from me. Thank you.
Thank you very much. Then without further ado, let's please promote the next witness to panelist. I believe our first witness, Ms. Clinton, is going to be Jack, Mr. Jack.
Yes.
Okay, great. So we are looking for assistance from the Zoom moderators to help us promote. Although looking at the attendees list, do I see?
Apologies, I don't see Mr. Jack in the attendee list.
Okay.
If he has some technical issue, we can get him a link. If that's an issue, you can send me his email address, and we can work on that right now.
Okay. Yeah, we originally had him scheduled for the afternoon of today, and we've since sent an update since we moved that around a little bit, but I haven't gotten confirmation from him that he received that and is available. So we might have to return to him once he sees that.
So I would ask that somebody from your office attempt to contact your morning witnesses and confirm that they are ready to go forward. I think we can, is there somebody who can work on that while you're still engaged with us?
No.
So I know that I know that we have Mr. Bricklin on the line, and his first witness, I believe, was Mr. Hill, who we were going to call second.
Yes, is
I don't see Mr. Hill on the list either. Mr. Bricklin, do you have a means of contacting Mr. Hill?
Yeah, I do. I'll do that as we're waiting here.
mhm.
So, and Ms. Clengen, if you could also contact Mr. Jack, and whoever we get first is who we would take first.
Okay. All right. One moment.
Thank you.
All right.
We'll just briefly pause.
As of yesterday.
Thank you very much for restarting the recording.
Sorry, thank you, Mr. Monroe, for starting that. Ms. Examiner, I was contemplating the exchange that we had among council and yourself yesterday at the close yesterday about foundational objections. And knowing how much Mr. Bricklin appreciates interruptions, I thought then perhaps we could address at the outset the proper scope of testimony for this particular witness, because he has been identified to speak on issues of water supply and utilities, but he is not an engineer, and he is not a water supply expert. He is a planner. And so I would like to make that foundational objection up front and ask for a limiting instruction on the scope of testimony. And if I may screen share for a moment, I will point the examiner's or draw the examiner's attention to Mr. Hill's LinkedIn page, which I printed yesterday, which details his experience as a planner at the county. He's a principal in his own planning firm, and he has been a planning director for a number of jurisdictions for many years, including the city of Sun Valley, interesting intersection with Snoqualmie, since I believe Mr. Hill followed Snoqualmie, previous Snoqualmie Community Development, Mark Hoffman at the city of Sun Valley. So I guess that's in the 6 degrees of separation category. But his experience is almost exclusively as a planner. And although the description of experience that the appellants offered said that he was an engineer, the sole experience listed here relating to engineering is in this 1.5 year period when he worked for a consulting firm immediately after graduating from college. And his education, and I will switch to the other screen share view. His education does not include any engineering degrees.
Okay.
Trying to get to the.
I can save you some time, Mr. Sturbank, where he's addressing water planning issues, we're not getting into the engineering design issues, as I think you well know, so you could save your breath.
Let's do. I don't feel I need to, absent contesting testimony that he is in fact educated as an engineer. We can let that go. I don't need to see the screen share from LinkedIn or otherwise. So I will ask Mr. Bricklin to please make sure the witness doesn't stray outside the items that he was identified as being called for that are still within the scope of the appeal, which are water supply, and to the extent that utilities does not involve sewer, which has been excluded, utilities. And does that satisfy your request for a limiting instruction, Mr. Sturbank?
Well, not entirely, Ms. Examiner, because I don't believe, absent the engineering foundation, that he's qualified to talk about water supply. And that involves water rights and a number of technical engineering considerations, hydrogeological engineering, distribution, and a number of things. So again, it's hard to know, and typically I would hold those objections for the questions. Understanding Mr. Bricklin expressed his dislike for that approach, I was trying to be efficient and raise the objections up front. I would understand if the examiner would prefer to rule on those on a question by question basis, like we could take them up at that time.
I would request that those go to the weight of his testimony. They can bring that up during cross-examination and deal with it that way instead of interrupting the testimony again today, as was done so often yesterday.
Certainly. So that is what I had decided to do, in fact, is to ask the parties to be confident that I am capable of assigning appropriate weight based on the person's credentials, and that I will not be deceived as to the credentials of the witness.
Certainly, Ms. Examiner, and the city has high regard for your ability in that regard. Didn't mean
Could
to
we
suggest
proceed with
otherwise.
getting?
Excuse me, Mr.
Could we proceed with
Brickland.
getting the witness on?
I'm
I
trying to
know we're
finish
all
my.
concerned about timing,
Excuse
and
me.
I just hate for all this
Okay.
chit chat to be interfering with getting our case on, and then at the end of the day, we're said, hurry up, and it's
Understood.
because opposing counsel has eaten up half of our time.
Understood. I do hope that Mr. Monroe is promoting Mr. Hill to panelist while we're having this conversation.
Ms. Examiner, just to complete the legal objection, as we raised yesterday, adequate foundation is a prerequisite for the admissibility of expert testimony. It is not a question of weight, although certainly the examiner is entitled once the foundation has been laid to make considerations and rulings on weight, but it goes directly to the question of admissibility. And so I understand Mr. Brickland's dislike for interruptions, but they need to meet their legal burden before the testimony they're offering is even admissible. And Mr. Brickland knows that.
All right.
Will we proceed now?
Yeah, I'd like to proceed with the witness testimony. If we could have Mr. Hill, good morning. Thanks for joining us. If we could have you please state and spell your name for the record, give us the correct title by which you should be, like job title, by which you should be identified in the findings, and then please allow me to swear you in.
Okay. My name is Jay Hill, Jaehill, and my job title is Principal Planner at King County.
Thank you. And if I could ask you please to raise your right hand. Do you swear or affirm that your testimony will be true? If so, please say I do.
I do.
Thank you. Mr. Brickland, please go ahead.
Thank you. Mr. Hill, I don't know if you heard any of that discussion that was ongoing as you were getting elevated to panelist status. Counsel for the city has indicated he's concerned that you have limited engineering background and therefore you're not competent to address water supply issues. I'd like you to start by providing the examiner with some information about your background, but as you do, please be, please focus on the city lawyer's concerns about your competence to address these topics.
Thank you. So yes, I'm currently the chair of the King County Utilities Technical Review Committee, and I'm responsible for water and sewer system planning for the county. And that's in cooperation with state agencies, local utility providers, and we follow a variety of state and county laws in doing so. So yes, as I did mention that I had experience as a water supply consulting engineer. I never said I was a professional engineer or licensed engineer, or that I was here to speak about engineering specific topics. And so I am not misrepresenting my credentials in that regard. I did have an official job title as an engineer, and the work that I did at Montgomery Watson Harza immediately following that title, where I was specifically associate engineer, continued the exact same work on just with a different title, although kind of an interesting title. And so let's see. So yes, prior to joining King County, I was a planning manager or director for 8 years. I've been working in a variety of planning related disciplines, whether that be water, linear utilities, municipal planning, et cetera, for almost 17 years now. And I have a master's degree in environmental planning from Cal Poly. I'm a certified floodplain manager through the Association of State Floodplain Managers. I'm a certified planner from the American Planning Association, and I am an APA AICP commission member. I serve as the chair of the National Membership Standards Committees, and I'm very acutely aware of ethical issues, as that's one of my charges, and I take umbrage at being called out on ethical issues.
Thank you. Your in your current position as chair of the Utility Technical Review Committee, what's your responsibilities related to water system planning in particular?
So I am the first point of contact for basically all utility related issues throughout the county. So whether that's a citizen who wants to connect to water or sewer and isn't unclear of the process, to municipalities and other water providers getting their water system plans through review by the state Department of Health, Office of Drinking Water. We provide local government consistency, and where applicable, the plans must be adopted as a sub-element of the King County Comprehensive Plan, and therefore we undertake the review of the plan and facilitate the adoption by the council of the plan. And so, for example, any purveyor, whether they be a water association, a water company, or a city or special purpose district, they must submit their plan, which is then reviewed, and we prepare an ordinance and it becomes adopted as an element of the capital facilities plan in the case where there is direct provision of service or future provision of service to county residents. So if a city was only facilitating or only submitting a plan within their city boundaries, we wouldn't necessarily need to take a look at that. But when they are providing in the unincorporated county, then we absolutely do.
Yeah. And you touched briefly on your past engineering background. I don't know if you called out particular, were you a water supply consulting engineer for the Los Angeles Department of Water and Power?
Yes, so I worked originally as a subcontractor for a company called Pacifica Services, which had a subcontract with MWH, and I worked for the Los Angeles Department of Water and Power as staff in their Bishop Aqueduct office. I was in the office for a year, and then I moved to Pasadena to continue work with MWH for another year after that, maybe a total of 2 to 3 years. And while I was in Bishop, I authored about a dozen well field studies. I did a deep well aquifer pump test. I actually got to present some of my results related to the use of digital terrain modeling in groundwater hydrology at the CalGIS conference. And so I did a lot of really interesting things related to mod flow models and got published for it. So it was fun.
All right. And then let's talk a little bit about your background a little closer to home and to the issues at play here. Have you been involved in any water planning efforts in the North Bend area over the last several years?
I have, as part of my responsibility with the UTRC, I oversaw the adoption of the City of North Bend Water System Plan, the Salal Water Association Water System Plan, and a couple of different appeals of water service, timely and reasonable water service determinations in the North Bend area related to service provision between either City of North Bend and a potential customer, or there were a couple of appeals between kind of determining boundaries and provision between the City of North Bend and Salal Water Association.
Can I jump in just real quick? I had asked attorneys who aren't guiding witnesses through testimony to not video share, and Mr. Sturbank, you're video sharing. I just want to be consistent. Thank you very much. Please go ahead.
Thank you. And has that work or related work involved review of or involvement with various water right applications and mitigation projects in the upper Snoqualmie Basin?
That absolutely has, yes.
So did we ask you to testify today regarding the adequacy of the draft and final EIS regarding water supply issues?
I'm sorry, can you ask the first part of that question? Cut out.
Yeah, did we ask you to be available today to provide testimony regarding the water supply issues in the environmental impact statement?
Correct, yes.
And what steps did you take to inform yourself or prepare yourself for that testimony?
So my original comments in the comment letter, I believe, were dated July of 2020. And so that was, I reviewed the draft environmental impact statement and prepared the comment letter or prepared my portion of the comment letter. There were a number of county staff who I believe are also testifying that had other portions of that. But so that was reviewing the draft EIS and taking a lot of the knowledge that I had gained over the course of my North Bend proceedings to provide those comments related to water rights. And then for today's review, I have re-reviewed the sections from the FEIS that were the responses to our concerns, or maybe lack thereof responses. And I, during this intervening time period since the original comment and years ago now, I guess, I have begun review of the city's water system plan, but that was subsequent to even the delivery of the FEIS letter. So it's really just for my edification for today, but I don't plan on speaking to the water system plan.
And when you prepared the comments on the draft EIS, that was exclusively in your role as a county employee. That was before you had any contact with the appellants in this case, right?
Correct.
And so did you reach any conclusions regarding the adequacy of the water supply for phase 2 and phase 3 of the proposed development?
The DEIS itself stated that there was inadequate water supply for phase 2 and 3. And so really my review of that was just kind of ground truthing and seeing what potential options there were. And I reflected those concerns in the comment letter that any new sources of water would be junior to current rights and to the in-stream flow rules, which dramatically limits the options for the provision of water to phases 2 and 3 of the project.
All right. Why don't we take a moment to explain why that would be the case? What is the in-stream flow rule, and why would that limit the options?
The state of Washington created what is called the in-stream flow rule. There's maybe a more technical name to it, but it's commonly referred to by the in-stream flow. Anyway, and it basically states that a minimum flow must be maintained within the watershed for the purposes of the watershed for the ecological benefit. And there's been
in other words, you have to leave enough water in the creek for the fish and
the other species, correct?
Right.
And so there needs to be an amount of water left within the stream, and the Snoqualmie Basin is already by most accounts oversubscribed. There's been a bevy of state Supreme Court cases, Hearst, Foster, Postuma, et cetera, since then that have limited our ability to even permit exempt wells because of their potential impact in these impaired watershed recovery areas. And so essentially kicking the can further down the road, saying, we'll find water later. There's not much water to be found. There's different ways of moving water around. There's the potential of acquiring rights. There's other possible ways. I mean, it's not impossible, but it is, as recognized in the city's own planning documents, very difficult to do this in the future.
And in the EIS, did it identify specific solution for this water shortage problem that would impact phase 2 and phase 3?
It did not identify specific solutions, no.
Is it possible to analyze the impacts of providing water for phase 2 and phase 3 if the solutions for the water shortage aren't provided and addressed?
I don't believe so.
How is it that I mean, it's difficult because the EIS doesn't provide solutions, but given your knowledge, and you said you're familiar with other planning documents and so forth, are the various solutions that are conceivable, would they potentially have adverse impacts on others, on other users?
Objection, lack of foundation.
So we're time stamping this objection for the record, and we're going to address that on cross. Is that correct, Mr. Sturbank?
I will certainly follow up on cross. Yes, Ms. Examiner.
Thank you. Okay, please go ahead.
And so the question is, Is
Yeah.
there the potential for the potential solutions to have impacts on other water users? Is that
Correct.
my understanding of the question?
Yep.
Correct. Essentially, there's already too many straws in the same cup, and without adding more water to the cup, more straws makes more problems. So,
And are some of those potentially impacted users in the unincorporated county?
very likely, yes.
Okay. Is that part of the reason why the county had an interest in this issue and had you comment on it in the draft EIS stage?
That is correct.
In terms of the information that's not provided in the EIS regarding how they're going to solve the water supply issues for phase 2 and phase 3, do you have an understanding of what's actually proposed in terms of the magnitude of development in phase 2 and phase 3? Or is this just a tiny little thing, or is it a significant development?
I mean, I can't really say what is significant.
All right.
I was
Fair enough.
once told significant is where the attorneys stop arguing. So I can't say whether it's significant or not.
Well, let me put it this way. Are you aware, I don't think anybody's contesting this, that phase 2 and phase 3 involves 400,000 square feet of warehousing and manufacturing, and that would be phase 2, and 800,000 square feet of office and campus, plus 25,000 of retail or restaurant in phase 3. You're aware of that?
Am aware of that, yes.
All right. And in terms of providing, when you testified that a water supply should be identified for those uses and the potential impacts to users outside of the project area, you had those proposed uses in mind in terms of the consequences that you're testifying to?
Correct.
That was a poorly worded question, but maybe you could put it in your own words.
My concern is, the approval of phase 1. There is admittedly, in the DEIS, there's water for phase 1, so approval of phase 1 is appropriate. Approval of phase 2 and 3, when there is water, would, clearly identified, would mitigate those impacts for all users, but specifically as my charge is the unincorporated county users. The timing of those and the adequate, addressing, what those water supply sources are going to be is of concern, because it really does seem just kicking the can down the road.
From a perspective of a water system planner, do you feel like decision makers or the hearing examiner or anyone else can be making decisions on the appropriateness of the proposed uses in phase 2 and phase 3 when there is no information about how water will be supplied for those phases?
Objection calls for speculation.
Okay, that's another, we'll timestamp that objection and address it if it all on cross-examination.
Do I answer?
Yeah, you can
that?
proceed.
Could you ask
Yeah.
the question again, Mr. Brookman?
Oh, okay. All right. Sorry, can you ask the question again, just to clarify?
I will.
Thank
Two
you.
requests
Sorry.
for that. That's fine. So my question is, can a person who's using the environmental impact statement to make decisions, such as the hearing examiner, can any decision maker using the environmental impact statement, would they have adequate information to decide on the scope and magnitude of uses in phase 2 and phase 3 if given the lack of any information in the EIS on how water is going to be supplied for those phases?
Yes, you cannot make a determination of the adequacy of the water supply such that it can be used to make a decision for phases 2 and 3.
Would it have, So given that there's this gap in information, would it have been exorbitant in terms of cost to obtain or to figure out what your water solution options are going to be?
And this time I'll object, calls for speculation.
Okay, thank you. We'll timestamp the objection. If you could please re-ask the question, Mr. Brickland.
Yeah. What would have, and I'll just put it a little differently. What would have, was there any reason why that you're aware of why the EIS could not include information on potential water supplies for phase 2 and phase 3?
It's they're able to identify potential options. I mean, they can give a menu of options, but how feasible they are, how much they'll cost, it could be very difficult, and it is the subject usually of other water system planning documents to identify those kinds of things. So it could have been done, but it likely would not have been in a meaningful way.
Without going through the more detail that you would have in another water system planning document, is that what you're saying?
Correct. I mean, you could list, you know, a whole bunch of things. I'm going to go buy a BMW, but until you know exactly how much the BMW costs, can you actually purchase that BMW? Is kind of the thing.
Right.
So
there are mechanisms for figuring out what other water supply options are, right? And that's something.
Correct.
And that's something the city ultimately is going to have to do. Correct.
Correct.
Is there any reason that you know of why that it couldn't have been done in conjunction with the EIS, as opposed to being, as you were saying, what'd you say, punted down the field or whatever, kicking the ball down the field? Is there any reason why it couldn't have been done in conjunction with the EIS instead of later?
It could have been done. There's no reason it could not have been done.
Right. That was my question. All right. In the comments you prepared for the county back when you reviewed the draft EIS, did you have concerns regarding the phased approach that the city's using with regard to the environmental review?
My only concern about the phasing has to do with there's approval of detailed plans for phase 1, and then a lot of the mitigation that would come later is in phases 2 and 3. So essentially, the development of phases 2 and 3, and therefore the mitigation or remediation of the site.
You're talking about toxic remediation.
Correct. Would be dependent on the acquisition of water. It's sequentially tied together, and so if you pull that first Jenga block out, then you don't get to the other ones. And so that was my kind of secondary concern. Primary concern is there going to be enough water for phases 2 and 3? But what are the other impacts of not enough water for phases 2 and 3?
All right, and so tell me if I'm summarizing you incorrectly. The other impact is if there's not enough water, and so phase 2, 3 never get built, then all the mitigation for the toxic pollution that's backloaded into phase 2 and 3 won't ever occur either.
Correct.
All right. You said that in addition to reviewing the draft EIS, that you also more recently reviewed the final EIS to determine the extent to which the final EIS responded to the comments that the county made on water supply on the draft EIS. Is that right?
Correct.
And what did you find when you reviewed the final EIS's responses to the county's water supply comments?
The comments were just that the city is in the process of updating its water and wastewater comprehensive plans, and to summarize, we'll figure it out. And that was not really an assuring statement on the part of the final EIS that these issues had been properly evaluated and addressed. It was just saying, well, we know it's a problem, we'll figure it out later. And that wasn't a sufficient response from the county's perspective.
You stated that one of the comments on the draft EIS was that the county, that the EIS needs to address the impact of any new water source on the users in unincorporated King County. Was that comment addressed in the final EIS?
It was not.
Was it even acknowledged in the final EIS?
I don't believe that it was.
All right, that is all I have for this witness. Thank you.
Thank you very much.
Thank you, Mr. Hill. The other lawyers may now have some questions for you.
Lawyers, plural. Okay.
One for
Yeah,
this,
there's a-
one for the,
it's-
one for the city, Mr. Sturbank, and then a lawyer, I'm not sure which one for the applicant.
So yes, we'll begin with cross-examination now. Mr. Sturbank, please introduce yourself and go ahead.
Okay, thank you, Ms. Examiner. Good morning, Mr. Hill. My name is Bob Sturbank. I'm the Snoqualmie City Attorney, and I represent the city in this proceeding. You talked a little bit with Mr. Bricklin about your credentials at the outset. I think you said you're not a professional engineer. Is that correct?
That is correct.
Okay, and are you familiar with what a certified water right examiner is in the state of Washington?
I am familiar with that.
And you are not a certified water right examiner, correct?
I am not.
Okay, and you are also not a licensed hydrogeologist.
I am not.
Okay, and in the course of your positions that you talked about with Mr. Bricklin, did you, as part of that, any of those positions, did you review and make decisions whether to approve water right applications?
I have not approved water right applications. No.
Okay. And so when you said that you have reviewed water right applications previously, I think with respect to North Bend, you were talking about looking at them as opposed to reviewing and making an approval, denial, conditioning decision, correct?
Correct.
Okay. And when you're talking about the county's current concern for residents of unincorporated county in the city of Snoqualmie's water, you're talking about unincorporated residents who are within the city of Snoqualmie water service area, is that right?
Correct.
Okay, and about how many people are we talking about?
How many people or how many residential connections?
How many residential connections? Let's start there.
Sorry, 1 second. Sorry, I had some notes here. I mean, we can say generally 100 connections.
Okay.
And if you want a more specific number, and
No,
give me a
no,
minute, I can find that. But
No, that's fine. I was looking for a ballpark, so thanks. So not a large number in terms of connections. Would you agree?
correct.
Okay, and those are folks who, or those are existing connections?
Correct. And then
Okay.
there's additional undeveloped lots within those service areas as well.
Okay, and what's the applicable zoning in the unincorporated area? Is it residentially 1 to 5? Does that sound right to you?
Generally speaking, correct.
Yeah,
There, because it's all within the urban growth, well, most of it's within the urban growth area, but in the unincorporated potential annexation areas around the city.
Okay, and are some of those areas constrained, have floodplain, wetland, or other constraints on development? Do you know?
Correct. Yes.
Oh, okay, and you were talking about most of the area is in the urban growth area. There is a portion. You familiar with the area colloquially you refer to as Ernie's Grove?
I'm not familiar with the name Ernie's
All
Grove.
right,
I
so
apologize.
that's okay. The portion of the city's water service area between Canyon Springs and the boundary, the incorporated city boundary.
Oh, okay.
Are you familiar with that portion of the water service area?
Yes.
Right, and that's outside the city's urban growth area, correct?
sorry, I'm getting into some real specifics here over land use and particular sites and whatnot. So forgive me for not having all the answers readily at hand.
Okay, no, that's fine. Would you agree though with the general proposition, if an area is outside the city's urban growth boundary, it's not eligible for extension of city utility services? As a general proposition.
I mean, that's not exactly correct. There are a number of cities that provide water service outside of water service can be provided outside the UGA.
In limited circumstances under the Growth Management Act, correct?
No, we have cities providing water. We have water districts providing water. All of District 119 is outside of the urban growth area, essentially. Like there's water can be provided outside of municipalities and water districts.
Well, I guess we can take up that legal issue separately. There's at least, you referred to some Supreme Court decisions. You familiar with the Cooper Point versus Thurston County decision?
It was specifically related to sewer.
Right, but that section of the Growth Management Act refers to utilities, does it not?
It
That's an
does.
issue in that case. Okay.
But I mean, like, okay.
All right, but in any event, with respect to existing connections, we're talking about 100 connections and potential areas where there might be water expansion of city water service are limited by existing zoning, correct?
Correct.
And other environmental constraints, right? Do you have any idea of what potential number of new connections might be in the unincorporated area?
That's hard to say because at the time of annexation, the zoning will likely change, and thereby minimum density, maximum density may apply. There could be more lots essentially created through subdivision processes and things like that. So hard to speculate.
But just talking about with respect to residents of the unincorporated area, which is the source of the county's concern that you testified to.
My concern isn't just related to current residents, though. It's related to current residents and future residents as well. But
right, of the unincorporated county.
Correct.
Right. Okay. And are you familiar generally with provisions in water system plans that outline the priority by which service will be provided?
I am.
All right. And in your experience, those typically establish a priority for in-city customers as opposed to located in the unincorporated area or unannexed?
I'm trying to understand the question. Just like, are there provisions like in the RCW that exist, or are there provisions
no,
within the city's documents? Or...
Correct. In the city's, all right, let's talk about the city's existing water service plan. Does it have policies that establish priority for customers in the city as opposed to in the unincorporated county?
I don't believe that there's a priority established there, but there may be.
There may be. Okay. And are there, is that typically a part of a water system plan? Policies relating to future connections?
There are always provisions related to future connections, but as far as prioritization of within city, out of city, et cetera, that's not super common.
Okay. That's up to the water system purveyor, correct?
Correct.
Okay.
And in some cases, it's caused consternation.
Okay. Now you mentioned, I think, that you had reviewed the city's water system planning documents. Is that right? Generally?
There was a, we'll say I did not review them for the purposes of today's testimony. It's not applicable. My testimony is just referencing the comment letters that I prepared previously and my subsequent review of those things. The water system plan I didn't receive until after that had all occurred, therefore didn't weigh into my considerations.
All right. Although both the draft and the final EIS speak to the city's ongoing water system planning process, do they not?
The city's ongoing process was happening, but I had not received the document from the city at that time.
I understand your point. The draft and the final environmental impact statements, though, however, reference that ongoing process, correct?
Correct. Yes.
Okay. And you mentioned that the city's documents speak to the planning documents, identification of possible solutions for water supply challenges going forward, correct?
Correct.
Okay.
When you say the city's documents, you're referring to the DEIS and FEIS documents.
I'm referring to the city's draft water system plan update.
Okay, you just said the city's documents refer to ongoing processes.
Correct. The city's,
So you're meaning the water system update refers to ongoing processes related to securing additional water supply or whatnot.
yes.
Yes, not part of my original testimony.
Understood, but that discussion is contained in those documents, right? You've reviewed them enough to identify that portion of the discussion.
As I understand, you were trying to impeach my ability to speak about this topic, and I'm trying not to. So take a favor or don't. I'm not talking about it, and I mean, if you want to, I mean, I specifically remember seeing that you guys did not want to hear my opinions on the draft water system plan at this time. So what's it going to be, Council?
I'm sorry, Mr. Hill, you're not here to argue with me, although maybe you would like to.
I came here.
I'm following up. Excuse me. I'm following up on a statement that you made that you had generally reviewed the planning document update, although you weren't here specifically to talk about that. Is that a fair summary of what you said?
I have generally reviewed the document, correct?
All right. And generally, you're aware that it identifies potential solutions to water system supply questions, correct?
Potential solutions, yes.
Okay. And the county has you are I think testified that you're the chair of the UTRC, correct?
Correct.
For the record, being the Utilities Technical Review Committee. And you are the chair, are you not, by dint of the county code provision that specifies that the person appointed by the Land Services Division will serve as the chair?
That is correct.
Okay. And the UTRC has various guidance documents that speak to its process for review and approval of water system plan updates.
That is correct.
Okay. And those guidance documents provide for a 90-day period for review and comment and approval?
They do.
Okay.
Excuse me, Mr. Sturban. Yes, I'd like to interpose an objection regarding the relevancy of this. These documents did not exist at the time that the draft and the final EIS were prepared. They were not incorporated by reference in those documents. I don't understand how these could possibly be relevant. And in fact, as the witness just indicated, as of yesterday, it seemed like the respondents agreed with that. But in any event, I don't see why we're wasting time with this.
Yeah, Mr. Sturbank, I thought this was a topic we weren't going to address in this proceeding.
Well, Ms. Examiner, as I indicated, Mr. Bricklin has identified that document as an exhibit, and it was, as did the city, wasn't stricken. The witness testified to its existence, and contrary to Mr. Bricklin's assertion that didn't exist at the time of the EIS, it did exist. I think, entitled to ask the witness about their process for review and whether or not they've complied with their own process. And maybe Ms. Kaler has a response here.
Well, I do. In writing in my notes regarding this witness's testimony, Mr. Bricklin asked, are you able to identify potential options? And the witness responded, that's the subject of other water system planning documents. I'm not sure Mr. Sturbank's, he can obviously speak for himself, intending to go deeply into that, but I believe he's responding to that particular item of testimony.
Well, I can tell where everybody's going with this, and I'm happy to explain our process. Sure.
1 second. Let me just, so Mr. Sturbank, if you're going to proceed down this road, I just feel like you're opening a door to wider discussion, and you had asked to limit the discussion or exclude this discussion. So I'm just confused. If you want to proceed on this line of testimony, then
I just wanted to establish whether or not the county has gone through its process regarding the city's draft plan update.
Why doesn't he ask that question?
I was about to when
Okay.
council objected.
All right, well, let's jump to it.
I think what I had asked the witness about whether they had documents that govern their review process. He said yes. So then I would ask the witness, has the county followed its review process and its guidance documents with respect to the city of Snoqualmie draft water system plan update?
In December, I was notified by RH2 pursuant to a different project that
Excuse me.
It's
Excuse me.
just a yes or no question.
no, it's
Yeah, right.
actually not. It's really funny, and this is gonna be
but
very
hold on.
interesting for everybody
Yeah.
involved.
Mr. Hill,
Right.
hold on, please.
Yeah, it might be interesting, but it might be more time than we need on this subject. Whether, I think it was just a yes or no question. I mean, have you reviewed it or not? But again, I want to emphasize that the EIS does not incorporate this document. So I don't understand. I continue with my objection that this is collateral to the issues before you. And I don't mind spending 10 seconds having him acknowledge that he's reviewed the document, but
I didn't receive the document until March 18th. So
okay.
I haven't had time to run it through our process.
So the answer is no, the county has not reviewed the water system plan using its process.
It is currently under review and will be heard at the April 20th UTRC meeting, which will be like a 32-day turnaround time instead of 60 or 90.
I appreciate that. That's, I think, the first notice that we've received that that's forthcoming, but thank you for
I've
your
spoken with your consultant about that.
Any more questions for this witness?
I did actually reach
Hold on,
out.
Mr. Hill.
Mr.
Hill,
hold on.
hold on, wait for a question.
Okay.
Yeah, we need to wait for questions, and I'm just trying to. Obviously, there's all kinds of stuff going on in the background that I don't know about, and that I probably ought not to know about. I don't want to get into any of that today. I don't want to get it on me. So if we could just stick to what's relevant to this appeal hearing, that would be great.
So, Mr. Hill, when I think Ms. Kaler referenced this, the portion of your prior testimony on direct, I believe you said when a water system purveyor identifies potential options or a menu of options, they're usually the subject of other water system planning documents. Are some of those other water system planning documents you were referring to water system plan updates?
Can be, yes.
All right. Did you have other documents in mind that you were referring to there?
I mean, there are other types of plans or efforts where people can identify water system, like strategic kinds of plans or, implementation of a goal from a plan in a more specific way. I mean, it's not limited to a water system plan until the time where it needs to be connected and approved by Office of Drinking Water.
Okay. But for example, a feasibility analysis, would that be another type of document that might be
Correct.
used? Okay.
Yes.
Or
there's water supply analyses documents that I've received where like that is the entire focus of that. It's separate from a water system plan, but it is a water supply analysis.
okay, and that can include modeling, for example, of
Correct.
all right. If I can take one more moment, Ms. Examiner, I believe I'm.
Excuse me.
Mr. Hill, I think near the conclusion of your direct conversation with Mr. Bricklin, you expressed some concern about the timing of remediation vis-a-vis of the site, remediation of contamination of the site on planning areas 2 and 3 with respect to development of planning area 1. Do you understand that the Model Toxics Control Act imposes independent cleanup requirements?
I'm not aware of the independent cleanup requirements.
So does state law govern, administered by the Department of Ecology, does that govern cleanup of contaminated sites?
I am not an expert in the Department of Ecology's rules and procedures.
Sure, and not asking you to express an expert opinion, but you mentioned remediation and cleanup. So are you aware generally that there is a separate process for review and approval of cleanups?
Generally, yes.
Okay, and that's administered by the Department of Ecology?
Yes.
Okay, under the Model Toxic Control Act?
Likely. Again,
Okay.
not clear enough on the
All right,
specific
outside,
procedures. Yeah.
Okay, that's fine, right. But just generally, you understand that those procedures and requirements exist independent of local jurisdiction land use approvals?
I can't answer how independent those are. So.
Okay. All right, I have no further questions at this time, Ms. Examiner.
Thank you very
Thank you,
much.
Mr. Hill.
Thank you very much. For the applicant?
Yes, thank you, Ms. Examiner. Good morning, Mr. Hill. I'm Courtney Kaler. I am representing the applicant. You are so fortunate to be able to speak with 3 attorneys this morning. And I'll be the last one here. I just have a few questions for you. Hopefully won't take too long here. So we've talked a little bit about your experience already today. Don't want to belabor that too much. I believe at the end of your conversation there with Mr. Sturbank, you had indicated a lack of knowledge of MOTCA, Model Toxic Control Act specifically. Do I take it then you are not an expert in the area of hazardous contamination and cleanup? Is that correct?
I am not, no.
All right. We didn't really hear about that much about your experience with SEPA. Can I ask, have you ever served as a responsible official under SEPA?
I do currently, related to the utilities technical review items. I have several threshold determinations and DNSs that I've published as a result.
Okay. And just generally with regard, not with regard to that, to the specific item of water supply, but more generally as a land use planner, have you ever served as a responsible official for a development project?
Like from the perspective of the developer or from the perspective of the city or?
Well, let me back up
Sorry.
and clarify my question. The term responsible official is a, do you know what that means?
No, I do, absolutely.
Okay.
But you're saying that did I serve as one for a development project? You're meaning as the city's responsible official for a specific development project?
As a city or, yeah, so let me clarify what I'm asking. Have you served as a responsible official on the part of any government agency, it's a city or a county, in an environmental determination on a development project?
No.
And so am I understanding correctly that your role currently is, does that include providing comments on SEPA documents relating to water supply?
It does.
Does it involve providing comments on SEPA documents relating to any other topic?
Trying to think in my current role what other SEPA documents I've commented on. I think it's all been related to water in my current role. Water, sewer, utilities.
Thank you. And I think that's probably all of the questions I have with regard to that matter. wanted to follow up on a little bit of your testimony that we've had some questions about previously. And just correct me if I'm wrong. I'm reading from my notes. I want to be sure that I understood what you said. That in your opinion, what I have is that this project or developer or city would be able to identify potential options for water supply for planning areas 2 and 3. Is that correct?
I'm saying they would be able to. Sorry.
No,
That was a question. You're saying that I stated that they would be able to.
So let me rephrase. I'm looking at my notes on your testimony, and I believe that you were asked if that was possible, and you responded that that would be the subject of other water system planning documents, not the document you're talking about, the EIS. Is that right?
I think the sum total of my comments is that they could have done it in both. You could have identified specifically within the EIS, here are some potential options, but also that if not in the EIS, it would absolutely be covered in the water comprehensive plans.
And so there is a planning process, the water comprehensive plans that you just responded to, you just mentioned, that provides a method for a city to review its potential future water supply options. Is that right?
Correct.
Okay. And as part of that process, would it be possible for the city to identify water supply for planning areas 2 and 3?
It is possible.
Okay. And as part of that process, would it be possible for the city to address service outside of its jurisdictional boundaries in the areas of the county that are covered by its water service plan? Would that be possible?
It is possible.
Okay. And as part of that planning process, then would it be possible for the city to identify ways to address any impacts on those users?
The impacts are from the development, not from the water system. So the impacts would not be in the water system plan. The impacts would be in the EIS.
And so would it be possible as part of that process for the city to identify how to serve those users with water?
As part of the water system process, would it be possible for the city to identify how better to serve the unincorporated county residents? Is that the?
Sure.
Then,
Quite rephrased, but essentially, yes, that's what I'm asking.
Yes.
Okay. And based on the information that you have today about planning areas 2 and 3, is it possible to do that?
As part of the water system plan or as part of the EIS?
Well, either way, let's say as part of the water system plan.
Well, the water system plan would need to assume that phases 2 and 3 would have to assume it as part of their modeling, as part of their planning assumptions, land use assumptions, et cetera. So assuming that they did that they included the entirety of that within the water system plan, it's feasible to identify impacts. But that's an entirely separate action.
And so as I'm understanding your testimony, it's that's possible. You just think it should have been done already. Is that right?
Well, it's if you have them done in the water system plan and the water system plan is adopted ahead of an EIS, you could cite the water system plan and say that the impacts had been calculated and mitigated, whatever, appropriately. if it's done after, that seems kind of like a retrospective look at the development impacts. So.
And so again, I just to ask my question again, as I am understanding your testimony, you're acknowledging there's a process for this, but saying you believe it should have been done already. Is that right?
I'm not saying that the water system plan should have been done already. I'm saying that in as much as phases 2 and 3 extend beyond the city's acknowledged ability to provide water service, phases 2 and 3 should be adequately accounted for. So whether that's done in an adopted water system plan or in an FEIS or whatever, it should be done somewhere, but it should be done before approvals of those phases are granted, concluded.
And so again, my understanding of your testimony is not that it's not possible to do that. It's just really a matter of timing, in your opinion. Is that right?
Correct.
Okay. I do not have any further questions for this. Actually, I may have further questions. And no, I don't. Thank you.
Thank you, Ms. Kaler.
Things to help.
Mr. Bergman?
Yeah, and so just one question to follow up on all that. And so the timing issue is that before the city makes a decision on whether to approve these uses for phase 2 and 3, they should have figured out where the water supply is going to be coming from and what the impacts of that would be on others. Is that right?
Correct. One way or
I have
another. Yeah.
Right. Thank you. I have nothing further.
Okay, are we completed with Mr. Hill's testimony?
We are.
Mr. Sturbank, we're completed. You had, okay, great. Thank you so much, Mr. Hill, for your testimony. Really appreciate it.
You're welcome. Thanks.
Thank you.
All right.
I believe at this point, Audrey, I can hand the baton to you. We're going to have Pam Jenkins come back and testify to those 2 items that were
Great.
held over from yesterday.
Thank you. That's a great idea. Let's do that.
Good morning.
Good morning, Ms. Jenkins. Let me just remind you that you're under oath to tell the truth, and then we'll just have Ms. Clungeon go ahead.
All right, thank you.
All right. Hi, Pam. I understand you have some answers to the questions that were posed yesterday. So the first one regarding sites you have been involved with that have or involved boiler ash. So can you provide us some detail on that?
Yes, I will. And I have to say this was not an easy question for me to answer. So I'm actually going to take you back through some of my professional history, if it may take a few minutes to do that.
Okay.
When I finished graduate school at the University of Washington, I went to work for the air program at the Department of Ecology in Olympia. My primary function there was to issue permits for large emission sources, as I had mentioned yesterday. I also, in that role, started getting phone calls from people who people who had compromised lung function, and they were calling me, telling me, I can't open the windows of my house at night because there's so much smoke that it comes in the house and then I can't breathe. I also, at this time, became acquainted with Janet Kolupnik, who at that time was I don't know if she was president or chairman or whatever, of the Washington chapter of the American Lung Association. She also had heard from many people who had similar complaints. So I began just getting up to speed on this issue and realized that this was a real air quality concern. At that time, the air quality program for which I was working for had a large network of air quality monitors, all of which were established in industrial areas. There wasn't a single monitor in any sort of residential or neighborhood area, which was quite revealing, because nothing in our monitoring system revealed high levels of particulate that might explain or corroborate these complaints that we had been hearing from on the phone. So I discussed it with my manager at the time. And he said, oh, no, we only control industrial emission sources. So we had a bit of a discussion. I went back to the Washington Clean Air Act and found that, in fact, the air control that ecology was supposed to be looking at did not segregate industrial and residential areas, that our mission was to address air quality everywhere within the state. So this was a hot topic. Oh, sorry for the word, but because, as you may recall, in the mid 70s, we experienced the oil embargo, and the price of oil more than doubled in a very short amount of time. Price of gasoline did the same, and many people looked for alternate ways. Hello.
Yeah, Ms. Examiner, I apologize for interrupting, Ms. Jenkins. I don't want to belabor the issue, and I appreciate the background, Ms. Jenkins, but the question was really just targeted to a list of any sites that you've worked on that have involved investigation and remediation of boiler ash. I appreciate the background, but I'm really just focused on understanding if there's specific sites where you have dealt with investigation, remediation under MOTCA of boiler ash.
Okay, thank you for that clarification. I understood the question to be more in regards to my understanding of what boiler ash is, how it is developed, and how it would be cleaned up.
Okay,
So the
so no, we're just looking for a list of
it
sites.
has to do with my knowledge about boiler ash. So anyway, so the sites that I have, these were active sites, not cleanup sites. The places where I have obtained, let's see, it wasn't remediation, but it was information regarding boiler ash, included the Port Townsend paper, Longview Fiber, and specifically Simpson Tacoma Craft Mill in the Tide Flats area. And it was in that latter that we did, my research partner and I did extensive research into various waste streams and how to reduce them from that particular plant, which was then published by EPA in several different articles. So I have knowledge, lots of knowledge, more than your average cleanup person about boiler ash.
Okay, great.
Okay, and oh, I apologize, Ms. Examiner, go ahead.
There was one more question.
Yes.
Yeah, just to clarify on that, you said those were active sites, not cleanup sites. So those were not MOTCA investigations and remediation sites. Those were actively functioning, it sounds like, industrial facilities.
That is correct.
Okay, thank you.
Right.
And then the next question was, they requested some information about a conversation that you had with the Toxics Cleanup Program Manager at Ecology. Can you
Yes.
provide those
And so I
details?
went back to my phone notes. I phoned Bob Warren at Ecology, who was then the program manager of the Toxics Cleanup Program. That was July 8th, 2020. And I asked him, do you need to know the subject of that conversation, or just that I talked with
I
him?
believe she asked for the name, the date, and a brief summary of content of the conversation. That's what my notes say. Is that correct, Ms. Carey?
That's correct.
Thank you.
Thank you. So the questions I asked him, the first question was, is the Toxic Cleanup Program actively, is someone assigned to this site? And his answer was no. It was not an active site on their list. And I said, is it going to be? I understand that there is some planning going on to clean up this site. And he said, right now we have a hiring freeze. In his program, there were 8 vacancies, and he had no idea when they would be able to hire. But at that moment in time, they did not have the capacity to take on any new site work.
Okay.
But I believe that you testified that you had conversations with two conversations with DOE people. Was there another person?
Yeah, there was. She was a new employee. Her name is Kim Wooten. She is a toxicologist. Let me see if I can find the phone notes. And I want to find these notes because I had talked to her about another site that was totally unrelated to this. And I don't want to confuse the two because I don't think I spoke to her about this. I think this was on another site that I'm involved with, but let me just
Do you have them readily available, or should we take a brief break and we can come back to it?
that might be a good idea. This is many pages of notes.
Okay, all
Let's
right.
do that. We'll take a
We'll be
break.
back.
If you don't mind standing by, Ms. Jenkins, we'll start with another witness's testimony and we'll try to come back to you before noon. Is that okay?
That's fine.
Okay. Thank you very much. Appreciate it. We will come back to Ms. Jenkins again. So at this point, we do need to have Richard Jack promoted, I believe.
Yes. Right now, so it says he's not an authorized registrant, and I've sent him the Zoom links for Mr. Rogers as well, and he hasn't been able to get in. Is there a new one we can send him or authorize him?
Could you provide me with his email address, and we'll have our IT department get him a panelist link immediately.
Great. Okay. So it's
Let me grab a pen. Sorry.
Yeah.
Okay, go ahead.
Okay. So it's richard.jack@kingcounty.gov.
Okay, I will have our IT people get him a panelist link right now. So hold on.
Great. Thank you. Okay, Pam, in the meantime, let's have you turn off your camera and then we'll send me an email when you've got the information. Okay, all right, thanks.
Perfect. All right, we'll just take a beat and wait for Mr. Jack to be promoted to panelist in our meeting.
Okay. While we wait for that, could we maybe do a quick 5-minute?
Sure, let's do. It's 10:26. Let's come back at 10:30.
Yeah.
We'll start up again at 10:30. Thank you for the idea. Great. Thank you so much for taking the time to look at your notes. Ms. Jenkins, please go ahead. Ms. Klungen?
Yes. Okay, so I understand that you were looking for an answer for the topic of conversation with Kim Wooten and the details on that. Can you provide that?
Yes, thank you for clarifying that. And I've gone through my phone notes over the period where I may have tried to contact her. I do have her name and a phone number written down and no phone notes, which means that I didn't reach her. So I have not talked to her about this project at all.
Okay.
I have no record of it in my phone notes during this period. But I talked to her about another project that has no bearing on this at all.
Okay. Ms. Correa, does that answer your questions?
It does. Thank you, Ms. Jenkins.
Yes, you're welcome.
Thank you very much, Ms. Jenkins, for your testimony in our hearing.
You're welcome.
Take good care.
Thank you. Bye-bye.
Bye now. Ms. Klungen, any update on Mr. Jack?
Nope, not at this time. So I think it might make.
Let me just ask, do you not have a phone number for him?
I do. I called it, but I was not able to get through. Email has been more responsive.
So do the parties want to wait a couple more minutes for Mr. Jack, or shall we start with Dr. Cook in the interest of efficiency? believe Miss Kaler was the person most concerned about hearing Mr. Jack as early as possible. Is that correct?
Well, we do want to be sure to hear contamination testimony today.
Was it
And
before
so that-
2? Or was
No,
there-
anytime today. I think I was mostly concerned because as the witnesses were lining up, it appeared that it was possible we would go past today, and I didn't
Yes.
want Mr. Jack to slide into tomorrow. I guess if Mr. Jack is not, for whatever reason, able to join at this point in time, I think given the time, it's fine if we start with Miss Cook, but if Mr. Jack does appear, perhaps we could, take him between cross-examination of Miss Cook, and I just want to be sure we get him on today.
Understood. Okay, we'll address the timing of Mr. Jack's testimony when he is available. Ms. Clengen, is there someone in your office who can please be in touch with him while you are involved with Dr. Cook? Or you are presenting Dr. Cook's testimony, correct?
Yes.
Yes. So is there someone who can help
I'll-
make sure?
Yeah.
Yeah, I'll work on it.
Thank you so much. Okay. And then, well, let's make sure, Dr. Cook, are you with us? Are you able to be promoted to panelist and present testimony at this time? We could have help from our meeting moderators. Thank you very much.
I believe I believe I'm on, but I
Great.
can't swear to it.
You
Yes.
are, we can hear you. All right, we just saw Mr. Jack is also in the meeting, so shall we?
I'm
Hold on a
willing to
second. Let
react.
me change my my background so you don't see my dog.
We have a lot of things happening at this moment. We were having trouble connecting to Mr. Jack, and so we decided to call Dr. Cook to come next. Now you're both here, and I can only hear one of you at a time. I believe Dr. Cook's testimony is expected to take quite a bit longer. I believe Mr. Jack's testimony is anticipated to be briefer. It would be my preference, Dr. Cook, if it's not too irritating, to hear Mr. Jack first. Is that all right?
That's
Thank you.
fine, absolutely fine.
Thank you for the thumbs up.
I'm probably a 20-minute talk here. My best guess, I don't
right.
really know. So
All right. We have you now, and so let's get your testimony in while we do. So if I could please have you state and spell your name, give us your job title for the record so I can identify you correctly in the findings, and then please allow me to swear you in.
okay, it's Richard Jack. J-A-C-K is how it's spelled, just like it says. I work for King County Department of Natural Resources and Parks. I'm a water quality planner 3.
Thank you very much. If I could please ask you to raise your right hand. Do you swear or affirm your testimony will be true? If so, please say I do.
Do
Thank you very much. Ms. Clengen, please go ahead.
All right, thank you. All right, good morning, Mr. Jack. All right, so let's start off here. I know you provided your title, but can you just give us a little bit of background in your role at the county and your professional experience?
So I've been working in site cleanup work for almost 30 years now, in a variety of positions with other agencies. And with King County, I support Matka cleanup projects on actual county property, including property owned by the Rivers program and property usually near rivers or along shorelines that's owned and purchased by King County for ecological restoration purposes. My background in general is I work sort of at the interface between a lot of technical issues around Matka site cleanup issues, predominantly water quality, but also sediment quality. Groundwater issues are common. Modest soil contamination issues are common on my current projects, but I've worked on some pretty contaminated sites in the past, including 100-year-old refineries, smelter sites. So it's run the gamut of different facilities that I've worked on in the past. most of county purchased property are relatively lightly contaminated nowadays. We don't purchase property with lots of environmental liabilities on them, but there's only so much riverfront going around, and sometimes there's contamination issues on that we need to address.
Okay. All right, and then I understand that did you participate in the review of the draft EIS and the FEIS for this project?
I did. I contributed technical comments to both of those letters that were, I believe, signed by Jim Chan from Department of Local Services.
Okay, and so in those letters, would it have been the environmental health sections?
Hold on, I will have to dig up my actual copy of that letter to confirm what the bullet point is, but I believe there was a bullet. Yes, environmental health is how it was titled.
Okay, and I can share my screen too if it helps for to pull some of these letters up. But okay,
I have them printed out, but I just wanted to confirm that I was looking at the right section. I'm not used to commenting on EISs, so this is a little new to me.
okay. All right, so let's look at the draft EIS. Your comments to the draft EIS that was in July of 2020. There were a number of areas related to environmental health where the county requested that the EIS provide additional information. I'd like to just walk through some of those.
Sure.
So the first one concerned potential for contaminated stormwater. And
Ms. Kludgen, it sounded like you were planning to screen share an exhibit, or at least if we could get an exhibit reference number so I know what we're talking about.
yes. All right. Right, are you able to see this document? This is a comment on the draft EIS. So it is included in the appendix or in the appendix to the FEIS, which is in the record. Okay. All right, so the first one here, we have some concerns about contaminated stormwater discharge. Can you tell us a little bit about that?
Well, right now, this isn't necessarily my comment. I don't actually work in contaminated stormwater usually, but
And Mr. Examiner, again, we're going to object to the extent that we're talking about stormwater, which is an issue that has been excluded.
Correct. The issue of stormwater has been excluded, and it's not his comment. So,
okay.
Moving
It was
on.
related to contamination, which is not excluded, but I understand. Okay. Okay, so then the next one here, if we want to move on a little bit. There is some certainty about industrial activities in planning area 1 and requesting additional information. Can you elaborate on that?
Yes, certainly. We've had many projects in the past, and it wouldn't be surprising that if there were lots of industrial activities in planning areas 2 and 3, that log storage, particularly treated log storage, would have happened in planning area 1, and that there would be either dip tanks or other facilities in planning area 1 that would be a source of contamination to that portion of the project.
Okay. And is it your understanding that there will be residential uses in planning area 1?
my understanding from the draft EIS is that it's a mixed use development, which includes residences and condos or apartments, in various forms for people in planning area 1. Yes.
Okay.
And Ms. Cludgeon, before your next question, I still don't know what page number we're on specifically in the document. So we need to understand what it is we're looking at right now on the screen.
Can you tell us at least the date of the comment letter? And do you know where it appears?
This is I can answer that question because I have it on in my lap here at the same time. This is the July.
I'm sorry, Mr. Jack. I really we need Ms. Cludgeon to help us understand where it is in the comment appendix. So that's why I asked her. Thank you, though.
That's fine. Sorry.
Yes. So it is a July 13, 2020 letter. It is included in the appendix of the FEIS. And I believe that would be Appendix A.
And the letter is from, what's the letterhead?
The letter is from it's the King County Permitting Division. It's directed to Mark Hoffman.
Thank you. And this question we were just looking at was subsection something E on in environmental health.
5E.
5E.
Correct.
Thank you.
Okay. So what is your, Mr. Jack, what is your understanding of the uses in the different planning areas of this project? The proposed uses?
That planning area 1 would be a mixed use development, including homes and other residential areas. Planning areas 2 and planning areas 3 are to be developed at some indefinite time in the future. I don't really understand exactly the proposal there.
Okay. But is it your understanding that it would involve development and various uses by people on a contaminated site?
Correct.
Okay.
Yes.
Okay. And then I just want to go down. So I'm just going to read from here. It's unclear if confirmation testing has been completed in this area to verify that soils are clean enough for residential uses. Did you write this section?
I did.
Okay.
Yes. Comment E is my language.
Okay. And then you've reviewed the FEIS, correct?
I did.
Okay. And do you know if the FEIS addressed this concern?
It did in part. There were some supplemental investigations that were done between the draft and the final EIS. My supposition is that the amount of investigation was reasonable for planning purposes, but it was not necessarily adequate for decision-making purposes to verify if soils were cleaned up to residential standards in planning area 1.
Okay. All right. And then similarly, further down, some concerns regarding creosote.
Yes.
Could you elaborate on that a little bit?
So creosote is a highly toxic wood preservative historically used on this property.
And again, this is Ms. Kaler, just anticipating a little further down in this paragraph. There are no claims in this appeal relating to fish or aquatic species. Those terms do not appear in the appeal, and so we will object to any testimony on that issue.
So pre-warning of an objection, please continue with your question and testimony, Ms. Cludgeon.
Yes.
And just for the record, we're now looking at 5 subsection F.
Yes.
Thank you. Please, re-ask your witness the question he is responding to.
Yes. Mr. Jack, could you elaborate on some of the concerns regarding creosote on the site and their proximity to Borst Lake, which was raised in the appeal?
So creosote is a highly toxic wood preservative that was used historically, very commonly used historically, and a lot of creosote treating practices from places similar to the mill site historically were relatively sloppy. And so it's commonly found in soils and at mill sites and industrial parcels similar to this one. It is oftentimes mixed with some of the more toxic contaminants known, which are dioxins and furans. Those were a byproduct of the creosote manufacturing process. The county is very concerned about how all of those contaminants can and may be people and fish may be exposed to that entire mess. Either
Again, I'm going to
directly-
object to this testimony. Impacts to fish or aquatic species were not raised as an issue in this appeal, and therefore we object.
I'm going to note the objection for the record and ask the witness to continue testifying.
So as I brought up in our written comments, the county is concerned about the continued release of these contaminants and exposure of these kinds of contaminants to both people and the environment, which includes to groundwater as well. And to date, the investigations that have happened, particularly in planning areas 2 and 3, have been inadequate to fully understand where those contaminants are, if they're even present at all, and where they're migrating to. Now, the reason why this potentially is for us as a county agency relevant to the approval of the project as a whole is because the cleanup of planning areas 2 and 3 may impact people that are living in the planning area 1 zone, which is anticipated to be completed first. So we would like to see a full accounting of those, of what the anticipated cleanup actions are in planning areas 2 and 3, and how they may or may not impact planning area 1 as it is developing in the near term. One example of how these impacts could translate from planning areas 2 and 3 into planning area 1 is it's very common at large industrial facilities like this to require something called a corrective action management unit, which is also abbreviated a CAMU. A CAMU is essentially a solid or dangerous waste management facility, can oftentimes take the form of a landfill, a lined landfill that is intentionally planned because it's
Excuse me, Mr. Jack. Yeah, before we get too far down this road, I need to make an objection. This calls for speculation. The witness is testifying about, guesswork essentially in terms of what may or may not be required. So just noting the objection.
And so Mr. Jack, you haven't been here all along. Let me just let you know, because of the virtual meeting, I'm asking attorneys to verbally interrupt with their objections. And in the case of speculation objections, I'm noting them. And then we're going to continue with testimony.
Well, I will circle back to that issue in a second here. So right now, the draft and final EIS are not complete enough to really understand if something such as a CAMU or other waste management approach might be necessary in planning areas 2 and 3. And so we would like a more full accounting and investigation of those areas so that those impacts, if they're present, can be described as they relate to planning area 1.
Thank you. Okay. All right. Right, and in this letter, I just want to find another section here. Or here. So your language, the county would like to see more information on the risk from contaminants under the plan and how the redevelopment reduces exposures and ultimately remedies historic contamination. From your reading of the FEIS, has it addressed this concern, this request for more information?
In part on planning area 1, it has with the supplemental investigations. There's been, as far as I can tell, no concerted effort to address this concern on planning areas 2 or planning areas 3. And yeah, so no.
Okay. And for the supplemental investigation on planning area 1, have you had a chance to review that document?
Yes.
Okay. And what are do you have any concerns about that document being a summary and not providing data?
Yes, certainly it would be nice to and give a more fuller accounting and record of exactly what happened in terms of the supplemental investigation in planning areas 1. That would be useful as an appendix. But the site as a whole has definitely not been fully investigated, and that's really our biggest concern. And I think that concern is also shared by other agencies. Ecology recently completed a risk
Objection.
ranking of this property. And okay.
Yeah, 1 second.
I'm sorry, Madam Examiner. This calls for hearsay and speculation. I'm just going to try to speak to what other agencies may or may not have said or think.
And I second that objection for the same reasons.
Okay.
Well,
So we're,
okay,
we will ask you to speak to your direct experience, and if you do make reference to things other agencies have said that aren't in writing that you can refer to, it will be hearsay and it is excludable.
Well, let me put it this way: that assessment and risk ranking for this property is part of the public record. It was published in August of last year, and that is what this comment G is essentially stating in brief, that we are concerned about the risk for the property as a whole, especially with the redevelopment of planning area 1, potentially increasing exposures of residential of residences.
And again, I'm objecting. It calls for speculation. His conclusion that there's some increase in risk for residential exposures. There's no basis that's been asserted for that so far in his testimony.
I'm going to note your objection and ask the witness to continue.
I would also just note regarding the hearsay, Mr. Jack, as an expert, is entitled to rely on hearsay and information that would inform his opinion, so he can provide that context.
So just now we were discussing paragraph 5G of this comment letter.
Yes.
Thank you.
All right, one moment. I just want to respond. And regarding speculation, I mean, Mr. Jack has been involved in cleanups, and here we have a contaminated site with proposed residential uses. So to the extent that the contamination could impact the residential or the residents on the site, that is relevant.
And my objection is simply that there hasn't been any foundation or basis laid for his opinion to that issue. And we haven't heard any justification or basis for him to opine and support that opinion at this point.
Was providing a site to a site hazard assessment, which identified this property as a number one or a ranking one in terms of contamination. So I would argue that he was laying that foundation.
And that respectfully, that site hazard assessment does not address this issue of a connection between contamination and residential uses. That's a very different issue. So again, I renew my objection on a lack of basis for his opinion.
All right. And again, I did already rule on the objection and say that it's noted for the record, and I'm going to ask the witness to continue with this testimony.
And if I may, Madam Examiner, Ms. Klingen referred to the rules of evidence, or that experts may rely on hearsay. The particular rule of evidence is ER 703, very common for experts to be allowed to testify based on hearsay.
Ms. Examiner, maybe I'd be heard briefly.
Yes.
Thank you. With respect to ER 703 that Mr. Bricklin just cited, that it speaks to an expert offering an opinion, that they can rely on hearsay materials informing their opinion. It does not allow the witness to engage in hearsay testimony about what other agencies' concerns are and attempt to speak for those other agencies. And I believe that's what I heard from my notes where I interjected. Mr. Jack began by saying other agencies have concerns too, and that's where that was going. That's a lack of foundation speculation, and ER 703 doesn't allow him to speak on behalf of other agencies.
So Ms. Klingen responded to that by noting that he is referring to the hazard assessment that was published by Department of Ecology that's already in the record. So Ms. Klingen, could you please continue with your witness's testimony?
Okay, Jack.
I would like to, if I may, respond to the concept that we have an industrial site where nobody lives right now. There are no residential uses. There are no residential uses nearby the property either. It would be highly unusual where if we put people on the property and built homes on the property or adjacent to the property for exposures to potential contaminants. I can't say exactly what is present in planning areas 2 and 3 because a full investigation hasn't happened in those areas yet. But it is not unreasonable to speculate that exposures are only going to increase by having children and residences immediately adjacent to those planning areas.
Okay, thank you. And earlier you discussed some involvement in MOTCA and cleanup. Could you elaborate on that?
I'm not sure what you're asking. I'm sorry.
In your okay. In your role with the county, do you and working on MOTCA and cleanup, do you frequently interact with other agencies that are part of the cleanup?
Correct. Yes, we frequently interact with local jurisdictions where property happens to be within the city of Kent or Auburn or something like that, and as well as with ecology.
Okay. And is your opinion about the site informed and supported by other agency opinions?
Well, I would think it seems to be. Our concern that's expressed here on the screen in sub-bullet G is that the full accounting of the contamination and some understanding of what remedial actions are going to be required in planning areas 2 and 3 are relevant to the development of the property as a whole in particular, and are also relevant as to how those actions may influence planning area 1. And we in King County are considering the project in its totality, not necessarily as phased, because the phases are not accounting for cross-phase impacts to one another. And this is unusual for us, and we would like to see a more full accounting of the project as a whole.
Okay. Is the current information that in the FEIS adequate to make an informed decision of the probable environmental consequences of the proposed action as a whole?
No, I don't believe it is.
Okay. All right, now I would just like to, I'm going to turn from your comments on the draft EIS to your comments on the FEIS. So we're going to go to, for our purposes, this is scans exhibit 19.
And if you could enlarge it, Ms. Clengen, so that it's easier to see on the screen, that would be great.
Sure. Let me know. How's that?
That's good. Thank you.
Okay. All right. Mr. Deck, you testified that you prepared these comments as well to the response to the FEIS, correct?
In part, yes.
Okay. And can we just identify which sections those would have been?
Yes, so the bottom 2 rows on this page that you're showing on the screen right now, those would have been mine, yes.
Okay. All right, so let's start. So again, we have the toxic chemicals, creosote, and concern about that the report, the formal report is not yet complete.
Yes. It's very hard to tell if this is a sufficient, if the summary that's presented in the final EIS is actually a sufficient investigation or not.
Mhm. And what level of investigation would be involved to understand, what level of investigation would be involved to remediate the site?
So the site as a whole, I would be the process by which contaminated parcels, especially large parcels such as this, go through in order to reach a final cleanup decision can take quite some time. Usually there's something called a remedial investigation. This usually requires multiple phases to investigate all the different pathways. The reason for the multiple phases is usually because property unknowns are uncovered during phase 1 of investigation, which require additional work in phases 2 or phases 3. And basically a complete conceptual site model for a property such as this might take a number of years to develop to the point where we have a complete understanding of where all the sources are, what all the migration pathways are, what the risks are to people and the environment, and to develop effective remedies to either manage those risks or remove them.
Okay. Thank you for that. And then when I go down here, so you have a note where it's unclear how much soil in 2 and 3 needs remediation.
Yes.
And why is that important?
This is getting back to the similar issue. This is the remedial investigation and feasibility study that I referenced earlier. The final EIS was essentially stating that would be completed sometime in the future. And we don't necessarily disagree that for planning purposes, those final decisions would be in the future, but there's really no information completed about either of those, about either the pathways and sources that are present in planning areas 2 and 3, how they may be impacting planning area 1 right now. For instance, through groundwater migration or through stormwater runoff from planning areas 1 and from planning areas 2 and 3.
Ms. Examiner, I need to make an objection before we go down this path. Again, stormwater is an issue that has been excluded as one of the appeal issues. And so to the extent that he's offering opinion on that, his testimony should be excluded.
So, Mr. Jack, we did have a conversation at the beginning of the hearing in which it was determined that stormwater was not raised sufficiently in the appeal document to perfect appeal as to stormwater. I don't personally believe that means you can't mention the word stormwater, but please be aware that stormwater as a whole, as a concept, is excluded from the appeal.
Yes. I'm speaking of the opportunity for contaminants to migrate from downhill from planning areas 3, for instance, to other planning areas, not necessarily off-site even.
Mm-hmm. And yeah, just to be clear, you're not trying to testify that the proposed stormwater system on the site is somehow inadequate. Your comments are related to
That's correct.
Contaminants on the site.
Right. This is related to contaminant migration, either through surface runoff from one land area to another, or through groundwater migration, contaminated groundwater migration from one area or the other of the parcel of the property. There really isn't been a full accounting of those types of contaminant migration pathways yet.
Okay. And then also in the letter, you expressed some concerns about the phasing of the project and aggregation of the impacts. Could you elaborate on that?
So to date, the impacts from contamination on the property have not been addressed in their totality, and the way the project has currently been phased, addressing those contamination related impacts has been pushed off into the indeterminate future. The site has been on the MOTCA list since the law was passed in 1988, essentially. So it has been on the MOTCA list for 33 years. And there's no real timeline presented in either the draft or the final EIS as to when those contamination issues on the property as a whole will be the pathways and risks associated with the contaminants that are still there, or a remedial alternatives will be developed.
Okay. And I understand there were some concerns about the way that it's been broken, the project has been sort of segmented here.
Hold on, let me reread this comment again. I don't believe it was me. but yes, this is essentially what I've been saying for the past half an hour. Would you like me to direct? You have a question about it?
Yes, so in your experience for various cleanups, have you seen projects where, have you experienced projects where later phases aren't constructed, or are there any concerns about the feasibility of cleanup and leaving contaminated sites near developed sites?
Absolutely. It is actually not unheard of, but try and avoid it, where essentially the value of the property is developed or utilized first, and the liabilities associated with a parcel are ignored or pushed off into the indeterminate future to address. And this is where this comment on the final EIS is coming from, is that King County would like to see a closer linkage between the asset portion of the property in planning area 1 and the liability portion of the properties in planning areas 2 and planning areas 3, so that it doesn't continue to remain a brownfield into the indeterminate future, since it has been one since the mill closed in 1993.
Okay. All right, thank you very much. Those are all my questions.
Thank you very much, Mr. Jack. We'll have cross-examination now. I believe first we'll hear from an applicant attorney. I think it's Ms. Correa. Yes, great.
Yes, thank you. And if you just a second, Mr. Jack. So I wanted to start with your experience. It sounds like you have decades of experience in at least some contamination issues, but I wanted to get a better understanding of that. So how many years have you been working on MACA investigation and remediation projects?
Since I moved back to Washington in 2001.
Since 2001. And have you been doing that on behalf of King County since 2001, or have you been doing it for a private consulting firm? Who have you been working for?
I worked for this Department of Ecology Environmental Investigation Unit for almost 4 years. And since then, I have been supporting county cleanup projects since about 1995.
So for your county,
sorry, 2005.
2005. Thank you for that clarification. For the county cleanup projects, can you describe more your role in those projects? What is it that you actually do for those cleanups?
I usually, a lot of those cleanups are driven by consultants, but I'm oftentimes a project manager for developing the feasibility, the remedial investigations and feasibility studies. I contribute to the sampling and analysis plans. Sometimes I do the field work. That's a little bit unusual, but it has happened. And I develop the materials to submit to ecology in conjunction with the engineers who are doing the levee setback or the ecological restoration activity. I develop those remedial documents to submit to ecology for approval.
And when you're saying submitting documents for approval to ecology, are those the sites you're working on right now? Do they go through the voluntary cleanup program?
Almost all of them are in the voluntary cleanup program. There are occasionally some that are part of consent decree in the Lower Duwamish, for instance, but those are highly unusual for me.
Have you worked on any projects that involve consent decrees or agreed orders?
Not in the state of Washington. I was formerly an employee in the state of Wyoming for 5 years, and all of my, as a regulator, and all of my sites there were either under an agreed order or were under a consent decree.
Okay, thank you. And I wanted to understand your experience with the SEPA process in Washington State. Have you ever been a SEPA responsible official?
No.
Thank you. And trying to understand better the scope of your comments, or at least the comments that you're responsible for writing in the draft EIS and FEIS.
Okay.
It sounds like, so we looked at some comments that were in Appendix A to the draft EIS, which I believe is Exhibit C2. And were the ones that we discussed with Ms. Kludgeon that she asked you about, is that the full extent of your comments in the draft EIS?
Yes, the two comment letters from July 2020 and December 2021. The comments that she had up on the screen were the ones I was responsible for, and I did not contribute much to any other section of those letters.
Thank you. And none of those letters, neither of those letters were actually sent from you. Can you explain to me why there's the difference in the authors on the letters versus comments that you authored?
I am normally in King County, division directors would be the responsible official for signing comment letters to another jurisdiction.
Okay, and so did somebody in King County assign the task to you to comment on the draft EIS and the FEIS?
Correct.
Was that Mr. Chan?
The normal way we would address these situations is one of my supervisors, I have a few, would assign me to review a document, in this case, the EIS or both EISs. And we put together a comment letter, which is signed by the most appropriate division director. And so in this case, I was asked to develop technical comments by Josh Baldy, who is my division director. And because this was a SEPA related issue that Department of Local Services has the most nexus with, Jim Chan was the signatory of those comments.
Okay, thank you. That's helpful clarification. And so I'm going to share my screen quickly here just to, again, get some clarification on this. Can you all see this is Exhibit 19 again that we just went through your comments?
Can you enlarge it, Ms. Curry?
Yes, I will here. And
Thank
it's just a quick question. When you were testifying, you weren't sure, you said you weren't sure if you actually wrote this section that addresses failure to address aggregate significant impacts of the entire development. Did you write this section or did you not?
I believe I wrote portions of this, but somebody else edited it.
Okay, who else edited it?
I don't know. I'm guessing that it was probably somebody in Department of Local Services or Jim Chan himself.
Okay. So
that would be, sorry. I would just chime in that is not uncommon for division directors to receive technical comments from staff and work on them slightly themselves and not necessarily regurgitate them verbatim.
Okay, thank you for that clarification. And Ms. Examiner, we had objected to specifically Exhibit 19, but also had raised the general issue of wanting to make sure that the exhibits are limited to, admitting the relevant parts that are actually testified about and supported by knowledge of the witnesses. And so in both of these instances, the comments that were submitted related to Mr. Jack's testimony in Appendix A to the draft EIS, and then Exhibit 19, which we had specifically objected to, we would request that only the sections that he has testified to be admitted to the record and not the remainder of those documents, to the extent that no other witnesses are testifying to those issues.
Just to confirm, Ms. Curry, are you objecting to the city's inclusion of the draft EIS comment letter in Exhibit C2?
No, on that issue, Ms. Examiner, it's just making sure that we are following the guidance we'd asked for at the beginning of this hearing, that the evidence that is being taken into the record is reflecting evidence that is also being supported by the testimony and specifically spoken to. So certainly, you know, the entire FEI or Draft Eis is in the record, but we're limiting the issues that are relevant to this appeal to what has actually been testified and spoken to.
So does that
And
include
this is Ms.
only
Taylor, just to add, I think the specific objection was to
S19?
19, which is not the draft EIS comment
Right.
letter, is the final
Right.
final EIS comment letter, to the extent that is a thing.
Yes.
Just to clarify. Apologies.
So that's what I'm trying to clarify. So she's not objecting to portions of the draft EIS letter that he hasn't spoken to. I'm clarifying, I'm asking,
Mhm.
but is objecting to the portions of S19 that he hasn't testified to.
Yes, that's correct.
Okay. Just wanted to make sure I understood the objection. Mr.
Yeah.
Sturbank, did you feel the need to weigh in also? No, thank you. Thank you. Ms. Clengen, do you want to respond at all?
If, as long, I just want to be clear about then which sections of the letter we're acknowledging that Mr. Jack testified to.
Yes.
But also,
Did Mr. Hill also testify to S19?
I believe he did.
I believe Mr. Hill spoke to his letter, his comment letter on the DEIS, not to S19.
What I'm going to ask that we do is that the parties come up with a redacted S19 and submit that to me, and then we can discuss the proposed redacted S19 at a later time when we're not having a witness waiting around for us to do this business. Thank you.
Patient.
That works for us. Thank you, Ms.
Okay.
Examiner.
And that concludes your cross-exam, Ms. Carey?
No,
Oh.
not quite.
Okay. I just mistook your motion as the end, so please continue.
Nope. Just wanted to bring it up where it was most relevant.
I want to clarify, you want to have redacted a letter that King County submitted in response to the FEIS.
That is their proposal, yes. I haven't ruled on that request. That is their proposal. Can we move off that though and have that be a separate conversation and continue with the witness while he's patiently waiting?
Yes.
Thank you.
Okay. Thank you for listening to us on that sidetrack, Mr. Jack.
Yeah.
There's a couple other things on your background. You are not a licensed hydrogeologist, correct?
No, I actually work in toxicology.
Okay. And not a licensed engineer?
No.
Okay, thank you. We didn't get very much information on your professional certifications. Do you have any other degrees, professional certifications that are relevant to this that we should know about?
I have a bachelor's and a master's degree in environmental science. My recent focus for the last over 20 years has been on environmental toxicology and human health.
Okay, thank you. Are you aware of any data or information that creosote was used anywhere on this property? And I'm not asking for your speculation, but are you aware of any actual data?
The draft EIS discussed creosote dip tanks.
Okay. Were any of those dip tanks located in planning area 1?
I don't recall. I believe they were in planning areas 2 and planning areas 3, but I won't go on about that because I'm not sure.
So it sounds like from your experience, you're very familiar with the MOTCA Model Toxic Control Act and the processes under that. It's correct, isn't it, that the MOTCA process is a binding process on owners and operators of a site. And by site, I'm referring to it as a MOTCA cleanup site, and using that term in the way we would typically use it in the MOTCA process.
Yes, the owners of a parcel where there's been a release are typically the liable party.
And Ecology is the agency with expertise and jurisdiction. The Washington State Department of Ecology is the agency with expertise and jurisdiction to administer MOTCA and hold those parties accountable, correct?
Correct.
Are there any other agencies that are responsible for administering the MACA cleanup process?
To the extent that cleanup actions trigger SEPA requirements, there are oftentimes other jurisdictions, cities, or local agencies that are asked to comment and contribute to MACA cleanup decisions.
But they don't make the actual technical decisions under MACA, correct? The cities and counties don't take that role.
Unless they are the liable party, in which case I oftentimes represent the liable party. So unless, if it's a third party, you know, in this case, a warehouse or facility or whatever, no, outside of the SEPA process, no.
Okay. So if a local county city is not one of the liable parties at issue in a cleanup, they are not the regulatory agency that makes a determination of, you know, whether a MACA investigation cleanup, an RIFS, and a CAP is a cleanup action plan, all of that, whether that is sufficient under MACA. They're not the agency for that.
The ultimate decision-making authority, no.
Okay, thank you. And that ultimate decision-making authority lies with the Department of Ecology, correct?
Unless it is also a federally regulated site under another authority outside.
Okay, thank you. And so that would be a federal agency coming in if it was a CERCLA site, for example.
If it was a CERCLA site, for instance, or in some cases, the Toxic Substances Control Act is triggered by certain facilities. And so EPA would be involved from that angle as well.
Okay. And in this cleanup process, the Department of Ecology largely controls the timeline of a cleanup, correct?
No. I mean, yes and no. Applicants, liable parties, and people who have had releases of dangerous waste that trigger MACA are ultimately responsible for the cleanup, and they need to take responsibility for their poor waste handling practices in the past and initiate those cleanups. Waiting for ecology to issue an agreed order or some other legal mechanism to force the issue is not how the statute is supposed to operate.
Okay, but once a property owner or operator is in the MACA process, say they're working through the voluntary cleanup program or under even more binding under an agreed order, those timelines and what ecology expects of them, that's set by the Department of Ecology, correct?
For the properties that I work on, no. We complete those under the voluntary cleanup program. I mean, recently with King County, that is. We complete those under the voluntary cleanup program because we want to turn those properties back into productive uses. We do not wait for ecology to ask for documents or investigations. We do them of our own volition to expedite and move the process through to get to cleaner properties that protect human health and the environment.
Certainly, but even in those instances, have you experienced on any of your cleanup sites waiting for ecology feedback, say because of low staffing or just a delay in getting information or responses for whatever the reason back from ecology?
We mostly work through the voluntary cleanup program where we're not obligated to wait for ecology to respond to us.
Okay, that makes sense. Do you understand the difference between the voluntary cleanup program and the agreed order process?
Oh, absolutely, yes.
Okay, and you understand that the deadlines and the obligations under an agreed order are binding compared to the voluntary cleanup program?
Correct.
Okay. Are you familiar with the MACA cleanup standards, method A, method B cleanup standards?
Yes, quite familiar with those. I use those weekly.
And are you familiar with the concept of exposure pathways under MATCA and evaluating different exposure pathways?
Yes, that was part of our comments, that the full extent of the exposure pathways for the site as a whole was not well adequately characterized.
And so in the MATCA investigation and cleanup process, excuse me, is it your experience that the Department of Ecology would require a property owner or operator, whoever's the lead party on a cleanup, to evaluate the exposure pathways as part of that MATCA process?
I can't imagine that you could get to a final decision from ecology without a complete understanding of all those, unless it was a highly localized spill problem or something like that. But on a property like this, yes, that would be ecology's under ecology's control.
Okay, and that would include potential exposure pathways such as groundwater, surface water, soil. Am I missing any? Do you agree that those are all the potentials that are included?
Yes, certainly.
Okay. And in terms of a method A cleanup standard, if there are residential uses proposed of a property, in your experience, would ecology expect that the property meet method A cleanup standards?
As a general rule, that's sort of, those method A cleanup standards are considered like an expedited level. They're not necessarily a risk-based calculation on a site-by-site basis. So usually those are used at small properties without extensive contamination, where it's a few homes kind of excuse me, it's a defunct gas station or a relatively small parcel without extensive site-wide contamination over hundreds of acres. That was the intent of the method A numbers. We use them at King County quite extensively for other reasons, but yes, in the absence of those, normally a site would conduct a risk assessment and evaluate where the extent of the exposures and the areas over which people are actually moving and exposed to say, and through that process, site-specific cleanup standards would be established.
And you would expect,
okay,
and so you would expect that in that process of site-specific and/or MATCA method A or B standards being applied, that ecology would consider the potential for residential uses and what that might mean for a cleanup standard, right?
On a property like this, where there are actual planned residential uses, yes.
Okay, thank you. You mentioned that this site, the property as a whole, but you're referring to it as a site, has been on the contaminated site list for a number of years. But are you aware that there have been remedial actions performed in that time on planning areas 2 and 3?
Yes, I'm aware that there were a few underground storage tanks, for instance, that were removed along with some contaminated soil that was associated with them. So, I mean, there have been remedial actions.
Okay.
There just hasn't been a full accounting of what was there and how it impacted other resources. For instance, how those underground storage tanks leaked to groundwater and what residual contamination remains.
And so, and you've also reviewed the site hazard assessment that you mentioned earlier in your testimony that ecology prepared.
I have read it, yes. I did not review it as a technical for any kind of technical input. So it was a read it level of review.
Okay. Did you see in the site hazard assessment that ecology is currently treating planning areas 1, 2, and 3 as a comprehensive site under MATCA, at least according to that site hazard assessment?
Yes, and that was why I brought up the site hazard assessment earlier, because I believe that that is consistent with our comment letters that we wanted the site as a whole to be addressed.
Okay. And so under the MATCA process that we talked about, that's, you know, binding on owners and operators, we all agree on that point, it sounds like. Well, would the site as a whole have to be addressed under MATCA?
I'm not sure. Yeah, I don't see any way that it couldn't be.
Okay, thank you. No further questions for me, Mrs. Examiner.
Thank you very much. Let's check in with the city. So we have cross-examination questions for this witness from the city.
Just a few. Thank you, Ms. Examiner. Good morning, Mr. Jack. My name is Bob
Morning.
Sturbank. I'm the Snoqualmie City Attorney. Just a couple questions from your points. You were talking about your work for the county and returning brownfields to productive uses. Did I understand you to say that the county, as a policy matter, wants to see brownfields returned to productive uses?
Correct. Yes.
Okay. And with respect to the comment that you touched on, and I'm going to paraphrase here just from my notes, about wanting to see a closer linkage between asset and liability portions of a property. Is that also a policy preference of the county?
No, not that I'm aware of, no.
Oh, okay. But so that comment in your letter, that I'm just focusing on your comment about that. That's a comment about a choice to be made in approving development, is it not? As opposed to a comment about the substance of the EIS document?
So the speaking as a technical MATCA expert for the county, not as a policy person, I can say that the linking the planning areas 1, 2, and 3 into a comprehensive understanding of the whole property is something that we were interested in making sure was completed as part of the draft and final EIS. One of the issues that comes up because of the phasing of the property and because of the reality that a lot of the asset value appears to be in planning area 1, and a lot of the liabilities appear to be in planning areas 2 and planning in areas 3, that we were concerned that the capacity for this project to proceed as a whole was being segmented in a way that did not fully account for a lot of these technical issues, which are admittedly very expensive to address. And so that was sort of where the redevelopment tied back to funding related issues, in that, yes, we are interested in redevelopment as a general policy of brownfields, but we also don't want to see things phased so that the brownfields portion of the property is pushed out into the indefinite future either. I'm probably going a little bit further than I should as a policy person, because I am not.
Okay, but your point, and I appreciate the clarification, is about the phasing of the project development, right?
Yeah, as it relates to the cleanup of the site as a whole.
Right. Okay. And then when you were talking early on about concern about exposure pathways to residential uses, and you mentioned homes and condos, did you review the site plan as part of your review of the EIS?
Yes, I did as part of the draft. I did not have time to address that in the final EIS. So if there were significant changes, I'm probably not aware of them.
Did you actually see homes and condos proposed as any part of the project?
No, it was mixed use development, was my understanding.
Okay, would it surprise you if there were no homes included in the project whatsoever?
Yes.
Okay, would that change your view on any of this potential exposure if there's no homes included?
I'm not sure what's the definition of a home, because mixed use development as my understanding was, is that there would be people living on the property.
So let me screen share here for a moment. Okay, can you see that, Mr. Jack?
Yes.
Okay, I'm for the record, I'm showing the witness a portion of the draft environmental impact statement. It appears at page 26, and I think that's exhibit C2 for witness exhibit list purposes. So do you see that description right there,
Yes.
Mr. Jack?
Yes. I'm right there. I got your highlighted planning area 1.
Okay.
Mix of employment, retail, residential, pedestrian oriented village center, 160 housing units. So those are the homes that I was referring to.
Okay, and you see the description here that they would be apartments, second and third floor apartments?
Yes.
Okay, and I'm going to change the page here as well. Did you have occasion to review? This is the site plan in the draft environmental impact statement for page 82. Did you see that at all?
Yeah, this looks familiar.
Okay, can you point me to any homes on there?
Can you scroll up, please, so that I can see the legend?
Let me know if I should zoom in on any of the portion of this.
So the pink, if you scroll back down again, I'm not. So the homes, yes, that was my understanding, is that the homes were generally on the southeast portions of planning area 1.
So do you see here southeast portion of planning area 1 is all shown as open space?
Well, maybe I'm calling that the center or whatever, but they're the orange buildings with the pink on top of them, kind of in the central portion of the space of the property, is what I was thinking were the homes, as in residential apartments.
And you see you pointed to the legend for the pink indicates.
Yes, that's consistent with what I recall.
Right, and that's upper story residential common space is the pink, correct?
Okay.
Okay. I'll stop.
I'm thinking, are we getting our wires crossed here about what a home is? I never thought that there were standalone single family residences on the property. My understanding was it was always planned to be mixed use with ground level, like commercial kind of things, and apartments and condominiums above them. That's my definition of a home in this case.
Okay, does it change the exposure pathway at all if there are single family homes, for instance, with lawns, gardens, and landscaped areas, as opposed to parking lots and apartment buildings over multiple stories up?
Yes, undoubtedly the exposure pathways would have to be elaborated on in a risk assessment for a property like this, including what are the exposures for people that are working there? What are the exposures for people that live in this vicinity? And for both adults and children.
Okay, and that would be part of the MOTCA process that you were talking through with Ms. Carre, right?
Yes.
Okay. And with respect to your review of the EIS, the draft and the final, did you review the entire document or just portions related to the contamination?
I read the entire draft EIS but focused my comments on areas where I have expertise regarding MATCA related issues. And the final EIS, I look for mostly where if my comments had been addressed on the draft, and discovered that in most cases they had not, and that's where a lot of our December letter comments came from, is the fact that a lot of those issues had not yet been addressed.
But your review and comments focused on those areas where you have expertise as opposed to other portions of the document.
Correct.
Okay.
I only referred back to things like the paragraph that you put up on the screen a few minutes ago about what the actual development would look like on Planning Area 1 as it related to cleanup and MATCA related issues.
Okay. Thank you.
To make sure that I didn't misunderstand if there were, significant changes, for instance.
All right, thank you. I don't have any further questions, Ms. Examiner.
Thank you for
Thank
that.
you, Mr. Jack.
Thank you for that. Ms. Klungen, do you have redirect for Mr. Jack?
I do, just a little here. Okay, so we went into a little detail about the MATCA process. And just to clarify, I think we talked about MATCA is binding on this site, correct?
Yes.
Okay. And to your knowledge, has there been any sort of agreed order beyond that MATCA voluntary process?
No.
Okay. And just to clarify, this site has been subject to MATCA since approximately when? I think you said
1989.
Okay. So there's no proposed change for how this site will be handled now versus how was supposed to be handled previously. Is that accurate?
I'm not aware of any.
Okay. And does any of your MATCA testimony, does any of that impact your opinion that the city needs better information in the EIS to make its decisions about land uses approved on this property?
From our perspective, the final EIS is still incomplete in terms of being able to fully understand and describe for the public, as well as agencies like my own, the impacts of environmental contamination on the site as a whole, how they will be addressed as part of the remediation and redevelopment as an integrated project.
Okay. And okay. So is the information that might be provided to DOE through the MATCA process, would that be important for the city to have before it makes decisions about the land use and the intensity?
So I am not entirely familiar with the level of detail that might be appropriate for planning level decisions, but which is probably less than the amount of detail that ecology requires for a final MATCA related decision. But right now we have very little understanding of what's happening in planning areas 2 and 3 from a cleanup perspective. And to be able to provide a public accounting of what those actions are plausibly going to be would be very helpful from a decision-making process to be able to weigh the I'm trying to think of a better word than costs and benefits, because I think that's a little too fiscally oriented, but that's my point, is that to be able to weigh the how planning areas 2 and 3 impact planning areas 1 and the remediation of the site as a whole is an important point of public interest and is an important issue for King County.
Understood. Okay. And then I think you said that the bulk of the impacts are to occur in the later phases. Is that an accurate characterization?
Well, to the extent there's probably some impacts happening to date. Otherwise, as I mentioned earlier, the ecology site ranking of this parcel would not be at the highest priority level.
Mm-hmm.
But as far as the impacts and weighing the different alternatives in terms of potential cleanup actions, those are all deferred to sometime in the indeterminate future.
Okay. And you noted that the cleanup could be expensive. The cleanup for the contaminated site could be expensive, but isn't that part of the site owner's duty under MACA to clean it up?
It is, yes.
Okay.
And yeah, and I don't know the definition of expensive here, so.
Mm-hmm. But they would be under a similar duty regardless of a development proposal. Is that accurate?
Yes.
Okay. And regarding the people, I don't want to get too much into the debate about whether a house versus apartment, but on the site, but is it your understanding that there will be a number of people using this site?
Yeah, there's 160 residential units.
Mm-hmm.
That's at 2 people per residential unit on average. You know, we're talking 300 some odd people that are living here, plus additional people that are working here. So that's a significant amount of exposure that
Mm-hmm.
is not presently there.
Right, and safe to say that people leave their apartments and go and use the parking lots and open space on the site. Would that be accurate?
Yes, certainly. One of the county concerns is that we would have children now living in planning area 1 and essentially an uncontrolled MOTCA site in planning areas 2 and planning areas 3 with a lot more childhood exposures happening through just the kids being that much closer than they are right now.
Okay, all right. Okay, all right, those are all my questions. All right. Very much.
Thank you. Sorry to step over everybody who's thanking the witness. I was just also going to thank the witness. Thank you very much, Mr. Jack, for your testimony. Appreciate your being here today. That concludes appellant's third witness for today, and it just happens to be 12. Can we discuss lunch break, please, among council?
If you don't have anything else for me, I will sign out.
Thank you very much, Mr. Jack. You are excused.
Have a good day.
45, 30, 60,
45.
45. Ms. Clengen?
I think I said 45, but I'm open to any of those options.
45, good with everybody then. All right, so it's 12:01. Let's come back at 12:45. So 44. Thank you. We'll pause the recording. Thanks very much. We're back after our lunch break. I believe we are ready to go directly to appellant's next witness, who is Dr. Sarah Cook.
Yes.
Great. If we could have, thank you so much. Thank you for rejoining us, Dr. Cook. Thanks for your patience earlier while we took care of that other testimony. Before we begin with your testimony, just a few things that I'd like to bring to your attention. The appellants did offer your testimony to address a range of issues, some of which have been removed from discussion during the hearing. And I just want to bring that to your attention before we get started. Actually, the appellant's witness and exhibit list identifies you as addressing wetlands, streams, and critical habitat, and none of those areas have been stricken. So all testimony addressing those areas would be relevant. The portions of the items that have been stricken and dismissed from being considered in this appeal include stormwater, flooding or floodplains. Hold on, sorry, I was going to try to do that from memory. Two other things. The sewer is not under review, and we're also not discussing reasonableness of alternatives that were included in the FEIS. So I just want to bring to your attention, those 4 areas have been excluded from the scope of the appeal, and if your testimony even mentions those words, I'm likely to hear objections. If those topics touch on your testimony and it can be, a case can be made for relevance, you can offer that and we'll deal with the objections when they come, but those topics are not included within the scope of the appeal. So I just want to try to bring that to your attention before we get started. Also, I would like to let you know that the process, because of the virtual hearing, we're not all in the same room, the process that I've instigated to handle objections is that during the course of your testimony, the attorneys are verbally going to interrupt you, because it's my habit to take notes and I frequently look at my typing. So I may not see them if they're waving at me. I've asked them to verbally state objection. When you hear that, I'm going to ask you to please stop speaking so that the objection can be stated, responded to, and ruled upon before you continue with your testimony.
Understood.
Great. We have a procedural
Madam
question.
Examiner, yeah, I have a question on that. So lest the witnesses be too skittish about mentioning
Yes.
verboten words.
Yes.
So for instance, in Ms. Dr. Cook's testimony, I mean, she certainly can talk about flooding, how that impacts wetlands, and, you know, that wetlands are created or, you know, the hydration occurs during flooding events, but what's off limits is critiquing the EIS's analysis of flood impacts.
That is correct.
Right. All right.
It is correct.
And that
Thank you.
pertains to water quality issues also, am I correct? As they impact wetlands, I can discuss them.
Yes, the water quality issues have not been stricken, as specifically floodplain impacts flooding as an appeal issue, as well as sewers, stormwater, as in stormwater management provisions, and the reasonableness of alternatives that were analyzed in the FEIS.
Okay, understood.
And you're the first witness I'm trying this out on. We'll see if we can help forestall some of the interruptions that we've had with previous witnesses. Mr. Sturbank also has a procedural question.
Yes, thank you, Ms. Examiner. Just backing up, I had separately inquired of counsel over the lunch hour if we have a time estimate for Ms. Cook and a way to estimate when Gary Norris may be coming on, just so that we can coordinate with our other witnesses who may want to hear his testimony later today.
Great. Yes. So let's revisit that right now. I believe, Ms. Clengen, can you give us an estimate for this testimony?
Well, it's a little difficult given we don't know how many interruptions there might be. So we have provided the order of witnesses. We will try to get through them as efficiently as possible, but I think that might need to be a little bit of a group effort at this point.
Okay, but I think previously,
Approximately maybe an hour, hour and a half for Dr. Cook's testimony, and then it will be up to the applicant and the city how long that's going to go.
great. So approximately 90 minutes, and then let's say that we would please witnesses who are present, including Mr. Norris, who need to be present for Mr. Norris's testimony. Let's tell them that we don't anticipate starting that testimony anytime before 2:30. If they can stand by after 2:30, that would be appreciated. It'll probably be closer to 3, but I'm just saying, just in case. Okay. Hopefully that was informative and not intimidating. Let's go ahead with testimony, please. Could I have you please state and spell your name for the record? Then please give me the correct titles or credentials by which I should identify you in the findings. And then I would like to swear you in.
I am Dr. Sarah Spear Cook, SARAH SPEARCOOKE. And I have a doctorate in soils, botanical taxonomy, general ecology, and geology, and a couple of master's degrees thrown in there too that pertain to those subjects also.
All right. Thank you, Dr. Cook. Shall I call you Dr. Cook in the proceedings?
That'd be fine, yeah.
Great. If I could ask you please to raise your right hand. Do you swear or affirm your testimony will be true? If so, please say I do.
I do.
Thank you very much. Ms. Clungeon, please go ahead.
Good afternoon, Dr. Cook. Thank you. All right. So just in anticipation of various objections, let's first lay out your background. If I'd like to go through and do a thorough walkthrough of your professional and educational background and experience as it relates to the issues that you are going to discuss today. So
I believe my resume is one of the exhibits.
yeah.
But to summarize that, I have 36 years of experience in wetlands, ecological research, and environmental consulting, and 46 years of experience in ecological and geological research. That's actually across the world. 39 of those years, I've lived in the Pacific Northwest, so emphasizing those habitats. I have been involved in the past with a long-term research study through King County, the Environmental Protection Agency, and a few other funding agencies that looked at wetland ecosystems and the impact of urbanization on those ecosystems. And that's salient because I'm going to be talking about the knowledge that I gained from that study with respect to the impacts that might ensue from the proposed PCI project on the wetlands that are both on-site and off-site. I, as I said earlier, have 2 master's degrees, one from the McGill University in Canada in geobotany, and one from the University of Washington in botanical taxonomy, and I have a PhD from the University of Washington that included statistics, soils, and plant physiology. I did my undergraduate degree at Purdue University and McGill University. I have been a consultant in the Pacific Northwest since 1995 through present. I have taught classes at various universities in the region, University of Washington, the Evergreen State College, Portland State University. Most of those classes pertain to general botanical ecology, geology, or soils. And I have been a lecturer or taught classes for the interagency delineation group, which included the Environmental Protection Agency, the U.S. Army Corps of Engineers, and the Washington State Department of Ecology. I also teach classes through the Coastal Training Program, again, in in wetlands and botany and soils over the years, and have also taught. I teach classes for consulting firms on various issues, usually pertaining to plant identification. I think that's most of the salient information. I do, one thing I should mention is that I do third-party review for many jurisdictions in Washington State. Over the years, I think it's been over 20 different jurisdictions, from small to large. I also have been on staff for various small agencies as infill staff when they lose theirs. For example, the city of Seattle and city of Bellevue. So those are also salient that because it pertains to my understanding of how jurisdictions do project review for projects such as this.
Okay, great, thank you. All right, and for this project, I would like to walk through what was your task? What steps did you take to inform yourself about this project?
I have been tasked to evaluate the sufficiency of both the DEIS and the FEIS as part of my review for the citizens group for this project.
Okay. Oh, also, I just wanted to make sure we introduce Dr. Cook's resume. That would be scan exhibit 18. Okay, great. Okay, and I understand that you submitted comments on the draft EIS, is that correct?
That's correct.
Okay, and then also, let's see here. Let's take a look. So I just want to walk through some of the issues that you have raised in your various comments and overall. So let's start with the issues that you've identified in your comments regarding the adequacy of the information to make a reasoned decision for the FEIS.
As a part of my review of both the DEIS and the FEIS, I have identified 10 different issues that pertain to various topics, all critical areas associated. Of those 10, I'll go over them. I'm not sure if you want to ask me questions or you want me to do it in a narrative form. I understand that the narrative form is not exactly appreciated by opposing counsel, but I'm not sure how else to do it in this Zoom format. I'd like to point out, because there have been a couple of topics that have been restricted from discussion, that I will be talking about some of those issues, but it will all pertain with respect to their impacts to the critical areas ecosystems, both wetlands and streams, both on site and adjacent to the site. And I'll explain why the adjacent to the site is important in a little further in my testimony. So that will include the offsite receiving waters of Force Lake and the Snoqualmie River. Because it's important to understand these aspects to the overall site conditions. The site doesn't exist in isolation, and especially with respect to groundwater and wildlife usage, one needs to look at a landscape perspective, because water, both hydrology and water quality, and the income or the inputs of wildlife are all impacted by what happens both on site and adjacent to it. So I'll go into more detail on that in a little while. The first of the issues that I identified was contamination on the site. And I did a more detailed discussion of that in the DEIS, and even though we're more discussing now the FEIS, I think it's crucial to understand that very little changed with the information between the DEIS and the FEIS. So the topics I'm going to be discussing carry forward into the FEIS. And after I go over the subtopics themselves, I'll discuss my evaluation of the discussion or the comments that were made about my discussion in the DEIS that that were carried forward into the FEIS, and why I feel that they weren't addressed sufficiently. And I'll talk about that at the end. So the first issue was contamination. And I'd like to point out that, again, this is going to be with respect to its impacts on the wetland ecosystems and the wildlife that utilizes those wetland ecosystems. There's two aspects to the general ecology of a wetland with respect to water and water hydrology and water quality that can impact the wetland character, both the composition of the wetland vegetation and therefore the general habitat that wetland provides, and then the wildlife use for it. And that would be all guilds of wildlife, right down to aquatic invertebrates. And so changes to the existing hydrology, and in this case, because the state stormwater manual requires evaluating these systems back to pre-development conditions, that's kind of what I'll be deferring to, because we do know that this site has been utilized for in various ways since the 1800s, and so this is all salient. But the existing wetlands that are on site now, I've seen photographs. I have not been on the property. I will establish that right now, but I've read all the wetlands reports by Radke and Associates starting back to 2012 up through 2015, 2016, and 2017. And all the information on wetlands and streams that's been included in both the DEIS and the FEIS. So I need you to know that I do have a very good understanding of what the wetlands entail. I need everyone to get that the contamination is an issue. As part of the wetlands research program that I worked on, I have a pretty intimate knowledge of the impacts of things like PCBs and PAHs, et cetera, petroleum hydrocarbons, heavy metals, creosote on wetland vegetation. And one of the reasons that the wetlands on site, and there are 48 just on site, and then there's the wetlands associated with Bourse Lake and the Snoqualmie River, are all no longer of high quality, because a lot of the vegetation that would have been associated in much more pristine types of habitats cannot tolerate those kinds of water quality issues. The plants simply do not survive. And a lot of these are the plants that will provide food for the wildlife.
Excuse me, Dr. Cook, as the examiner indicated, I'm going to have to interrupt you, and I will apologize now for that and ongoing as I interrupt you in the future. I believe I just heard Dr. Cook say that all of the 48 wetlands on site are of not high quality because of contamination. I'm going to object on the basis of speculation and lack of foundation. There's been no indication that there is contamination in all 48 wetlands on site. Thank you.
Thanks. And so one thing I didn't fully clarify before is that I'm going to have attorneys, when they have objections related to foundation or to speculation, we're going to timestamp the objections so that it's caught in the record near your testimony. They'll address it further on cross so we can proceed at this point. Thank you.
Understood. And probably more accurately, I should just state that they've all been impacted between physical disturbance, chemical disturbance, hydrologic disturbance, and just being on a site that has had this much activity on it over all these years. So anyway, it's been discussed extensively in the record, the fact that the site has been utilized and that there have been processes that have occurred that have resulted in contamination. One of the things I'd like to point out is that we do not know the extent of the contamination across the site. And this is one of the things that the Environmental Protection Agency and the Washington State Department of Ecology have been addressing for decades, since the early, well, most of the reports come from the early 2020s, or 2000s, but there has been decades and decades worth of observations that the site has issues, including being identified as one of the most toxic sites in the state. So, and there's ample documentation of this, and I can quote a lot of the studies, but they're all in the record, Your Honor.
Here we get them in the record though at this point.
All right, so
Yeah, could I just have
let's see, we're talking about US EPA, well, these are all in, I have listed all the studies that I reviewed, both in the DEIS. So
Dr. Cook, let me just jump in, because one of the things we have to do is identify which exhibit numbers you're speaking to.
Well, that's
So I'm going to ask Ms. Klungen to call them out by exhibit number.
She's going to have to do that because I just listed the references. I didn't
exactly
list them as by exhibit numbers.
Yes.
So
let me let her identify some of those at this point.
Yeah, let's just start with we're talking about Dr. Cook's comments on the draft EIS, is where she provides a list of some of these documents. It's located in a couple of places, but one of them is Scan Exhibit 1. It was attached to their notice of appeal. It contains her July 2020 letter. And there we have a number of documents that are, I believe, part of applicant's record, part of the DEIS. A lot of them are exhibits to the DEIS. But then additionally, regarding the related to the site hazard assessment, those would be exhibits. Some of these have already been admitted. We have basically 11 through 13. We have a site assessment, and then the site hazard assessment that was done in August of 2021 are exhibits 4 and 5.
and I believe there's also, I think it's exhibit 14, the supplemental ESA for the UST area.
Yes, okay. We'd like to put that as well. That's the Delta Environmental Report. Let's see.
And it looks like maybe exhibit 7, the DOE class 2 inspection from 1994.
Okay.
And 5 and 6, DOE site hazard assessments and DOE cleanup site details.
Okay.
All of those document at least the Department of Ecology's and EPA's the preliminary documentation of issues, contamination issues on the site that would impact the habitats both on site and in Forest Lake. And I'll talk about how that impacts Forest Lake in a while.
Okay, great. Thank you.
And this is Courtney Kaler again, just for a point of clarification. I did hear Ms. Klungen say that a number of documents have been previously admitted. I actually haven't heard appellants ask for the admission of any document yet before now, with the exception of Dr. Cook's resume. So I don't think we need to clean that up right now here while Dr. Cook's waiting, but perhaps before they close their case, we haven't heard them ask for the admission of documents or then, been provided with the opportunity to object.
Agreed. We will go through the admission of exhibits before they close their case. And right now we'll have the witness testify. Yeah.
I just want to clarify. So if we have referenced exhibits previously, those are not included. We're going to have to go through them separately in order to have them admitted.
At the conclusion of testimony, we would probably have you offer the exhibits that you have had testimony regarding, and then we'll allow for the rediscussion of objections to the exhibits.
Okay.
Mr. Sturbank, something else? No. Okay, great.
Would it make sense for me could I introduce them as we go in addition to doing that at the end? Would that be more efficient, or can I reference the exhibits and then we address it at the end? Basically, I'm asking if I can get ahead of that now.
Sure. You and you have introduced just now. It listed S4, S5, S6, S7, S11, S12, and S13, in addition to Dr. Cook's CV at S18.
Okay. Okay, thank you.
And I also would like to point out that the Department of Ecology has reviewed the DEIS in at least 3 documents. The departments have commented, and I've seen those in the record. The toxic cleanup program, I believe, was addressed by the previous person who, prior to me, who just testified. The water quality program and the wetlands and shorelands program have all submitted comments for their reviews. It is also my understanding that they have not commented on the FEIS yet, and I'll talk to that because I have a personal communication with the lead at Department of Ecology who assigned the projects, and I'll talk about that personal conversation in just a minute, or a little further on another one of my issues.
And Ms. Examiner, I suppose I'll wait for Dr. Cook to start actually reporting on that conversation, but I will be objecting on the grounds of hearsay.
It would be great if we didn't get advance notice of objections, just because it takes up time. We're going to run short on time again. I don't want that to happen.
Just on the question about exhibits, I think it'd be useful at times certainly to offer them as they're used, so that if there's any question about how they're relevant to the witness's testimony and there's any need for follow-up question with the witness about that exhibit, it can be taken at that time. I would encourage both sides to offer the exhibits as they're used.
I've got a lot of those. I won't have the exhibit number, but
That's fine. Yeah, yeah. Ms.
So
can help
in
with that.
2021,
One second. Let me finish. Let me finish dealing with the comments from council. So I agree that they should be introduced during testimony. We didn't have. We had exhibit numbers mentioned during testimony yesterday. We didn't go through any formal offering and admission yesterday. I didn't know if you wanted to formally offer and admit them all at once at the end of today as a means of cleaning up the fact that we didn't do that yesterday.
Yeah, I think that's the ones that we've already gone by. We should do that all in one fell swoop. Those witnesses aren't here right now anyway, so there's no advantage.
Exactly.
Right.
Exactly.
And as to that hearsay objection, again, just
please let's not address it yet, though, because it hasn't even happened yet. So the more time we talk about them in advance, the less time we have for testimony.
All right, I hear you.
Okay.
Thank you. Sorry.
Thank you very much. Okay, please let us have Dr. Cook testify.
Okay, so with respect to Bourse Lake and its lack of inclusion into the evaluation in the FEIS, I need to point out that none of these systems, again, are in isolation, and that both the groundwater and the surface water flows, surface water flowing off the site into Bourse Lake and impacting Bourse Lake and the Snoqualmie River. And I will show, I've got some exhibits that Ms. Klungen will show in a little while that pertain to how those flows, current surface flows go. And then the groundwater, again, I'll address later on that there is lack of documentation that's substantial enough to really do a proper evaluation, but preliminary information from groundwater shows that the groundwater flows in both directions, both from the Snoqualmie River and the mill pond to this, both the deep and the shallow aquifer on site, and from on site into both Forest Lakes
And this
and
This is
Snoqualmie.
Courtney Kaler again. Apologies. This witness was to testify regarding wetlands, and right now she's testifying about deep aquifers. So if we could please limit this witness's testimony to what she's identified to speak about in the witness list. Thank you.
I'm going to overrule that objection. Dr. Cook is trying to speak about the context of how the critical areas, both on and off site, are affected, and the flow of stormwater is related to that. Flow of groundwater is related to that. So I don't believe she's presenting herself as a hydrogeology expert. That's not how I took her testimony. I don't know if you want to clean that up, Ms. Clungeon, now that it's been asked.
I think that's correct.
She went over her creds really extensively, and I didn't hear hydrogeologist, so I don't believe she's offering testimony in that vein. Let's let her testify.
Yes, there is not currently information in the wetlands reports that documents the source of hydrology to these wetlands, both on site and off site. So one has to assume as part of the water budget that it could be both surface water inputs and groundwater inputs. And so that's where the groundwater comes in. And although we know there is a shallow aquifer, we don't know its extent, and we don't know how much the deep aquifer feeds these wetland systems through discharge from the aquifers into the surface water wetlands. So I am commenting only with respect to there is a water supply. We do not know what it is. And this is also a lack in the documentation that should have been provided both in the DEIS and the FEIS through the wetland studies and the general hydrology information. It is lacking because we do not know what the source of the hydrology is, and it is required by local, state, and federal agencies that one has to maintain the hydrologic inputs to a wetland post-development so that they don't dry up and or become flooded. It's both more inputs and less inputs. And none of that modeling has been done. So we do not currently know from the information that's been provided whether or not the wetlands on site are going to be able to maintain their current characteristics. And that is something that it's critical for understanding and making an informed and reasoned decision when these reviewing agencies are reviewing this kind of information. And they're proposing to fill a significant number of wetlands, both in phase 1 and phase 2 and 3, and there will be some wetlands remaining. And so we need to know all this information in order to evaluate what's going to happen post-development. So get back to the contamination. It's well documented. The Department of Ecology in 2021 has given the site of a ranking of 1 in their site hazard assessment. And that is an exhibit. I don't know the number. Knows that.
I'm offering exhibit 4 and 5.
And worksheet 3 of that assessment includes Forest Lake. So it would have been important to understand that with respect to phases 1, 2, and 3. Second, the DOE has stated in their email from Karen Wooten on the April 30th of 2021, she's the ecology staff. As indicated by, this is a quote, as indicated by the list of data gaps in the ecology draft EIS comment letter, we do not consider.
And apologies again for interrupting, Ms. Clungeon. Could you please identify the exhibit that the witness is speaking to?
Yes. Dr. Cook, I believe we're on exhibit 4 for the site hazard assessment. Is that correct?
I think that's correct.
There are two with that title. Which date is this site hazard assessment?
4/30/2021 from Karen Wooten.
One moment.
Thank you. There are two exhibits called site hazard assessment. So the second one is the rank. So probably it's 4 S4.
Although I want to, the date that I have on that is 8/2021. So I just want to.
It's the draft EIS comment letter from the Department of Ecology.
Okay, so that would be a different exhibit. So we're talking about, let me find that. One moment. Okay, so these are comments on the draft EIS would be,
Exhibit C2,
one moment. Yeah.
appendix.
That I have appendix C for the FEIS as the transportation data. I thought that the comments on the draft EIS were appendix A. One moment. And these would be agency comments?
Yeah,
Okay,
this is the DOE's comment review of the DEIS.
okay.
We don't have any for the FEIS because they haven't done it yet.
Let me, just trying to find the page.
And the author again.
Kim Wooten. She's the ecology staff who did the DEIS review for the toxic segment.
Apologies, opening the document seems to have frozen my PDF viewer for the moment.
What are the
I have it,
what's
but-
the date of the comments, Dr. Cook?
4/30/2021.
Okay. There's been no objection to the DEIS as an exhibit, so I assume all the comment letters are admitted. Let's just call that sufficient and proceed with testimony.
And Ms. Examiner, I am just trying to understand, I'm trying to follow along. And
Yes.
if this letter is dated 4/30/2021, I don't believe it could be a DIS comment letter, just given the
Dates.
dates.
Yeah.
So since the witness is testifying about a document, I'd just like to know where I can find it and to actually know that it is an exhibit in this matter.
That is a good point. It can't be a DEIS comment.
And Ms. Examiner, just for record clarity, the comments on the DEIS are an appendix to the FEIS, which is Exhibit C1.
That
So
helps.
those comment letters would not be included in the DEIS.
Logic dictates.
Yep.
So Ms. Clungeon, are you looking for that for us?
For this document.
And it's an email, I believe.
And was it an exhibit, a disclosed?
Yes. Yes, I wouldn't have had access to it otherwise.
Okay, all right. Let me. And it is an email from Kim Wooten. Perhaps this is, hold on, I might have found it here. M13. Did you say it was April 30th, 2021?
Yes.
Okay, so I'm going to share my screen. I just want to make sure we're on the right document here. I believe this is M14. This document was provided.
Thank you.
Applicant? Is that
Yes,
correct?
that's it.
Yeah, the applicant. Okay, there we go.
So I just wanted to read a comment that she made in this letter. She says, as indicated by the list of data gaps in the ecology draft EIS comment letter, We do not consider the available information equivalent to a remedial investigation, and our expectation is that this type of sampling will be conducted in the future. And my point to that is that we do not know which of where the issues are with respect to toxins on the site. We don't know what there is. We don't know how what the concentrations are, and we do not know their location. So for me, it's difficult to comment as to whether or not any of the known wetlands, both the ones that are proposed to be impacted and those that are proposed to remain, if they're safe and will be impacted as a result of the development. I do not know, and that's my point, is that neither does the city, the state, or the feds. And so this kind of investigation is crucial to perform, because otherwise the state and the local, state, and federal agencies are tasked with protection of wetlands under no net loss, and we can't do that. We can't make an informed decision right now whether or not this PCI proposal will do that, will protect those wetlands. It's just not something we have information on. Next, ecology. Ms. Wooten went on to explain that, what ecology's role was with respect to SEPA, and she stated, as a reviewing agency, we provide feedback on areas of the draft EIS where we have specialized knowledge. We expect those comments to be addressed in the final EIS. And if you look at ecology's comments to the DEIS, you will see that, and I'll touch on this, not a lot has been addressed in the FEIS. And so, and ecology will presumably be commenting on the FEIS once they get their staffing issues settled, but we have not seen anything to date on that. So, and then the Farallon was discussed earlier, was discussed yesterday. By our expert in contamination, and that was the 2021 report. I believe that's already an exhibit. And they talk about sediment samples across the site. These were the 11.
Again, Ms. Cledgen, if your witness is talking about an exhibit, could you please tell me what exhibit it is so that I may follow along?
Yeah, Dr. Cook, if you'd let Ms. Clengen identify exhibit numbers, that'll help.
Yes, Dr. Cook, I believe you referenced the Farallon report.
Yeah, from 2021 that Pam Jenkins talked about yesterday.
Okay, so that would be, I believe that's an attachment to the FEIS. So that would be C1 from the city, I believe. We have the FEIS, and then it is exhibit. I don't know if there's a subsection here. Okay. Okay. So it would be appendix, so exhibit C1, appendix B. Just gonna expand this and share my screen here. So This, the summary of subsurface investigation of planning area 1.
Yes, I believe that's it.
Okay.
And Ms. Jenkins discussed that of the 10/11 samples that were taken were by no means sufficient to cover the contamination across the site. And again, we do not know, we only know what those pinpoint sampling locations. We know what the levels of toxins and contamination were in those 10 samples, but if I looked at the wetland map, I have no idea if they, I mean, I do know they certainly don't cover all the wetlands on site. And so again, knowing what levels of contamination are for those individual wetlands is not something we have a database for. So to proceed in the future, it makes it difficult to know where we are and whether or not these systems can tolerate any additional contamination impacts. And this would be through surface water flows once you've opened up the site through grading, and groundwater flows once you've done things like compact soils for foundations, etc. And then I also want to point out that the earlier studies that were done, and in the 2015 Boulder report, I don't know that, again, I don't know the exhibit number of that, Ms. Clungeon.
Yes, I am looking it up.
Let's see.
Yeah. Say 2015.
Yes, the 2015 report.
And who is the author of the report?
Golder and Associates,
Holder.
geotechnical firm.
I do not see that in the master exhibit list here. Where was that provided?
I believe it was in the EIS.
Okay.
I can find that.
You know,
I got it somewhere.
Was it in the FEIS or the Draft Eis?
I'm not sure. I assume it must have been in the Draft Eis.
Okay.
Let me see if I can find it. Anyway, they discuss figure 3 in that report shows.
And
the
again,
depth
I'm
of
just going to
fill.
interrupt
We
and
need to know the
I
exhibit number.
yeah.
Do you have a date for the report, Dr. Cook?
Yes, it's 2015.
That's the only date. Okay.
And was it related to wetlands or contamination?
It's a geotechnical report, and they did this particular report looks at the depth. They did sediment coring and looked, and the figure I'm referring to identifies the depth of fill across the site. And in a minute, I'll tell you why that's important.
Give Ms. Clungeon a chance to help us find that document.
We do have the map, the fill map. Is that what?
Oh, yeah, that's what I'm looking for.
Okay,
It was figure 3 in that Golder report.
I see. Okay, so that map would be scan exhibit Goldsmith. It was our exhibit 51, and let me just.
Oh, sorry, Goldsmith.
Let me make sure that I'm sharing the right document.
Yes, that's
Okay.
it.
So,
Thank you for finding it.
sorry about that. Okay.
And the reason this figure is important is it identifies the depth of fill across the site, some of which is contaminated and some of which is a capping material that is capping contamination. And the depth, if you can read that, which is, you can't read what you're displaying, but it greatly exceeds 2 feet. And the reason I'm pointing this out is that AESI's investigation in 2015, which looked at contaminants across the site, and then they did a further one in 2021.
Hold on, I just want to go back to the 2015 investigation across the site. I want to make sure we've got that as well.
And it's by AESI, also from 2015.
Okay. So that would, I believe that would be scan exhibit 10 or no. That contains a piece of it. Let me just find that.
Pardon me, what was the date of it?
The 2015.
Yes.
Thank you.
Was it this?
Well, it's their whole study, but that was, this is just a couple of pages that identifies some of the more contaminated areas on the site. But
What document are you showing, Ms. Clinton?
I am showing exhibit 10, scan exhibit 10. It's an excerpt from the 2015 AESI report. I don't know that I have the report in its entirety.
So
is your testimony related to this excerpt, Dr.?
Yes, it is. Well, to the entire report, but the excerpt has most of the information. The reason, and I'll refer to this excerpt again too, but the greater report talks about the sampling that they did was restricted to a 1 to 2 foot depth, depending on where they took the samples. And so I want you to understand that if you're documenting that the site has fill at a considerable depth and you're only sampling within the top 1 to 2 feet, you're not actually sampling the extent of toxins in the profile that are available to the plant communities in the wetlands. So I again am showing that there is a huge dearth of information on the site with respect to contaminants that could impact the wetland ecosystems and therefore the wildlife and et cetera. So, and I hadn't heard anybody point this out to date, and I think it's pretty critical to know that there has been limited sampling, and of that sampling, it's didn't even go down to a sufficient depth to access where some of the contaminants may be hanging out. So again, the lack of data on where the problems are across the site is glaring, and I really am not sure how the city and the state agencies and the feds are going to ever be able to evaluate with respect to the critical areas, what the impacts of this project might be, just from contamination. Right now, that's what I'm speaking to. So, and then, you know, so in AESI's 2015 investigation, there were just a couple of things I wanted to point out, that soils containing hydrocarbon concentrations above Mako cleanup levels are beneath a portion of where the common lumber shed location and strapping area used to be. And I did find the map for that. And Audrey, sorry, you have that. I think it's the first figure in the exhibits that I sent you this morning. So you could share your screen and show them so that the hearing examiner knows where these locations are.
Yes. Although I do need to know where it is.
It's in that exhibit document I sent you this morning where I pulled these so you could put them up on the screen.
Right, but you pulled them from documents that were in the record.
It's from the AESI 2015 report that I just talked about.
Okay, well, we have an excerpt of that. I don't have the document in its entirety. Would it be possible for you to send me the report or direct me to where you found it so that I can locate it?
I have the report. I've just renamed it. And so when we're done, I'll send it to you.
Okay. Well, the document that you sent, it's a map where it's illustrative of the point that you're trying to make. So would it be possible?
Yeah, I'm just identifying a couple of areas on the site that have wetlands near them that might, but the sampling wasn't done right in the wetlands. But these are just some examples of where there is contamination across the site that this AESI 2015 report identified.
Okay, I'm
And I'm gonna object to sharing or referring to documents that were not disclosed as exhibits.
No, they're from the record.
And in that case, I need to know what
Where
exhibit they
right.
are and what page in the record.
And I said I would find that. I
So before we share it, can we please do that?
The Radke report's in the record, correct?
The Radke report is, I believe, yes, 2015 and the update in 2017. But this is the AESI 2015 report. I think it's exhibit, no, that's just the, I was going to say, I think it's exhibit 10, but that's just the small part of it. I'm sorry, there's so many reports in this file. I renamed them so that I could find them.
Ms. Lingen, are you looking through the draft EIS documents?
Yes, I am. I'm also wondering if they were maybe part of the PCI application or somewhere else in the record.
They might be part of the PCI application.
Mhm.
It's something that I pulled off the city's website, so it is in the public record.
Well, there are 622 pages of reports attached in Appendix B.
I'll find it.
One moment.
But the first, where these locations are, and some are just adjacent to the phase 1 project, and some are in phase 2, and some are in phase 3. But again, through surface flows and groundwater, they could all be connected to the phase 1 area. And certainly
I'm
through
going to object based on speculation and lack of foundation that these could all be connected via groundwater. If we could just mark that point in the record. Thank you.
Objection is marked. It's a lot of scrolling to find this document. I'm afraid we are not making the most efficient use of our time.
I'll find it. I promise you I will find it, because it's something I reviewed in the last couple of days. So I've got it. I just I referred to just the report itself, thinking that that would be sufficient, rather than, it's likely an appendix somewhere. But I would have gotten it from the city's website. So for this project,
If it's attached to the DEIS, it is in the record.
yeah, or it's the PCI application itself, and I'm not sure which.
I think I have something that will show, it shows roughly the same information, maybe slightly updated. So this would be Appendix C to the draft EIS. I'm going to share that. It'll be page 99 of the PDF.
And actually go up to the previous figure. No, the previous one. No, the first one in the line that I sent you.
All right, I have to stop sharing because the first one that you sent, okay, I know that the first image that you sent is included in the draft, the main body of the draft EIS.
This is
that one up.
This is just to show where the areas are that I'm discussing, because this is actually from a different report, but this is from the Farallon report, which we've already put in the record. I just wanted to point out where these areas are that they're talking about in AESI, because this is the only map that I found that discussed where some of these historic.
You know, this hearing is so tedious.
You just unmuted yourself?
I know. You have to listen to all the
You're
people.
there you go. Goodness. So Dr. Cook,
The truer words are never said, huh? Sorry for that.
So I just wanted you to put up the figures so that I could talk about some of the areas where contamination has been found that are close to the wetlands that are on site.
Yes, I understand. And I know this document is in the FEIS, so frankly, this is slightly ridiculous, but
will any graphic do that identifies the wetlands, or are you looking for a specific graphic that shows the contaminated areas?
No, it's not even contaminated areas. It's just an area showing where the planning areas were and what used to be there.
it was the document that we reviewed extensively during Ms. Jenkins' testimony, where she was giving the context for the contamination on the site. I know it is labeled Figure 2, the location of mill structures during operation. I'm sure this exists somewhere within the various FEIS documents, which are part of the record. This is not a surprise, but hold on. It is a figure from Farallon 2019 Summary of Environmental Cleanup Activities.
this is my point. This is taking way too long. My point was just to put up the figure to show where the contamination had been found so that the hearing examiner could get an idea of where some of these areas are with respect to where the wetlands are. But why don't we, we'll find the documents and let's just move on, because this is just a small part of what I want to touch on, and we don't need to spend any more time on this.
Okay.
I mean, basically, I just were pointing out where hydrocarbon concentrations were found, where shallow groundwater showed that they were above MACA cleanup levels, where PCBs were found, and there is one particular area was called T12, it's called the press pit, that they specifically pointed out should remain isolated and protected from any future development because it was so highly contaminated. And then, you know, the PAHs that were discussed yesterday were at a very shallow depth at approximately the same elevation as that included part of the shallow groundwater. So again, if any of these wetlands are fed by shallow groundwater, which again, we don't know, there's the ones that are near to that particular area are at risk of being contaminated. So that was my point. And we don't, I'll find these references and I'll get them to the hearing examiner. So, so that I just wanted to establish that we know that the site is contaminated, that wetlands exist on the property, and they're at elevations where they could be fed by some by surface water, some by groundwater, others maybe by both. We don't know, and this is important. So the fact that there's contamination, we don't know where it is, we don't know where what the contaminants are, and we don't know if they're currently receiving these contaminants by groundwater or surface water flows, and we don't know post-development if they're going to be receiving contaminants by groundwater and surface water flows, because we don't have a handle on where these contaminants are and where they're a problem. So that's my point with the contaminant section. We'll go on to my second thing that I addressed in my comment letters, and that was emission of Mill Pond Bourse Lake when considering the development of the PCI property. And the reason that that this was important was because all the agencies in their comment letters, and again, I've already discussed where these are. One of them was up here in ecology's role as the SEPA reviewer, that that when they, in their SHA document, which didn't we just put that in the record as an exhibit? That would be
The site hazard assessment.
Yes, the site hazard assessment.
4 and 5, yes.
Their figure 1 identifies Bourse Lake as part of the area that historically received contaminants, and preliminary data shows that the sediments in Bourse Lake contain contaminants. And so they have included the Bourse Lake as being part of the overall site, and to exclude it certainly isn't going to give you an idea of what is going on with respect to movement of contaminants in the groundwater back and forth between the site and Bourse Lake. And again, I just discussed that to exclude downstream receiving waters from a site is against how every agency on the local, state, and federal does this work. I work as a wetlands consultant, and if there are wetlands within 300 linear feet of a property, I am required every time I do a delineation to include those wetlands. And so to restrict this massive wetland system from the FEIS seems very odd to me, when every other time, any other work I do in Washington State, adjacent wetlands and downstream receiving waters, which would also include the Snoqualmie River, would always be included in any evaluation I did. And the agencies would not review my work unless I included those adjacent and downstream receiving waters from the being assessed and evaluated.
Okay. And you made that comment in your draft EIS letter, correct?
Yes, I did.
Okay. And did the FEIS respond to that comment or address it?
No, it did not.
Okay.
And I won't talk about it. Yeah,
Okay.
it did not. So, and while as part of that site hazard assessment from August 20th of 2021, which is
Exhibit 4.
that's Exhibit 4.
Yes.
They also talked about the ranking system, the warm ranking system that they utilized, and that also included Horse Lake as part of that site assessment. So they considered the entire site as including Horse Lake. And then also I will point out that the drainage ditches on the site drain to the Mill Pond and Horse Lake, as shown in both the 2012 Radke report and the 2015 Radke report. And the figures that the next 3 figures that you have are of the Radke reports from 2015, which is part of the record too. We've already put it
Dr.
in.
Can I just ask?
They've broken up that site where this is the
And
first.
Mr. Examiner, can I ask once again that the exhibit and page number that the witness is referring to be identified?
We need the page, the
Dr.
exhibit
you say
number.
reference the figures. What are you referencing?
This is from the Radke report, wetland report from 2000. Here, it's figure 1 from 2015. From existing conditions, Radke report for
And is that
wetlands.
What
So let me
attachment?
see if I have that one. That is. Oh no, I renamed it, so I don't have the exhibit number, but I believe it's from the FEIS.
Okay, let me pull it up. Okay.
And if you would put that figure up while you're looking for that, Audrey.
Okay, is it in the FEIS?
No, it's in the exhibits that I sent you this morning.
Right, but those were excerpts from larger documents and I need to be able to tell them where.
Right, but if you put it up, you can see, maybe with the information it's showing, you can see. Somebody will be able to identify
it the
what
second-
document it is,
Was it the
what
second
exhibit it
document?
is.
Or the second image?
This is the second image, yes.
Okay, I found one that's similar and it's frankly more up to date. So I'm gonna go ahead and share that and you can tell me if maybe that's different from what you were envisioning.
Well, the reason I want you to put this one up is that it divides the sheet into smaller sheets, so that are larger in scale, so you can actually see the drainage off the site.
I see. Okay, hold on one second then.
So you can put the more up-to-date one and I'll just show it's just broken this map up into larger scale so you can see the 3 areas that are showing site drainage off into the Forest Lake / Mill Pond. So it's broken it up into sheets that
Mhm. Yeah, it says April of 2015. I don't have that somewhere else in the record. Would it be possible for you to send me this 2015 report just so that we don't have to? Go back and forth on this.
Yep, I've got that one too. I'll send that. So could you put that figure up for me?
I will, but the council is going to object. Unless they agree to allow it as an illustrative exhibit, and then we can provide the citation.
It's from their own consultant.
I understand.
I just need to know where it is in the record so that I can understand. I need to know where it is in the record so I can understand how it fits in with all the various other items that are in the record. So hopefully we can do that.
Here's what we're gonna do. We're gonna take a break. We're gonna take a break of, I'm gonna say 10 minutes, during which Ms. Clengen and Ms. Cook are gonna be able to confer about where the documents are in the record. And then we can proceed with testimony knowing where they are. So it's 2 o'clock. Let's come back at 2:10.
And may I just go quick clarification on that? If a document isn't on an exhibit list, but it's, a city or developer document, is it, I mean, I didn't read your scheduling order to preclude exhibits being introduced today if they weren't on exhibit lists, as long as there's no prejudice and unfair surprise. And it would seem like if these are documents from their files, even if they didn't make it onto an exhibit list, it would still be, there'd be no prejudice in using them.
As illustrative exhibits?
Well, no, I mean, all of these, some of these might be illustrative, some are presented for the truth of the information in the document, but if they're from their own files, I don't see how it can be unfair or prejudicial.
Well, I guess I would say one, we've had 2 rounds of exhibit disclosures, and appellants certainly have had the opportunity to identify what they're going to use. But I think more fundamentally, Mr. Brickland, we don't know whether they're in the record right now because we can't identify what they are.
I agree.
Let's get that
totally
done
agree
first,
with
and
that.
then we can have a discussion about whether we need to argue about any new exhibits.
Fair enough. Fair
Right.
enough.
Again, if there's just a basic identification of what the document is and where it is, whether it's in or out, then council have an opportunity to determine whether there's an objection to be made or not.
Correct. I assume all of these documents are in the record, otherwise Dr. Cook wouldn't have had them. So I just would like to take a break to give the parties an opportunity to point them out so we can dispense with the objections and proceed. And now it's a little later, so let's come back at 2:15. Please get a drink and stretch your legs, and we'll pause the recording and we'll come back at 2:15.
Okay.
Thank you.
Thank you very much. Ms. Clengen?
Okay. It would appear that Dr. Cook was relying on some documents that were provided on the city's website, but we cannot find them in the record at the moment. There are references to those documents in, I think if I'm correct, for it would be Appendix C to the DEIS, which is the wetland report. It has a list of documents that they relied on in that report, one of them being the 2015 Radke report that Dr. Cook is referencing, but it's a large document, so she's sending that to me now.
Okay, and do the appellants intend to introduce this document in the record?
Yes, once once I have it and I'll share it with all the parties, but it is a document prepared by the applicants. It's their own experts. This is not new information.
I was just seeking to confirm that that's your intention.
That is.
Is it possible, without addressing that issue, is it possible to proceed with testimony today based on the reports that are attached and that are in the record? Just going forward? Or do we need to address the admissibility of this document?
Can I speak for just a second? I don't see how either the DEIS or the FEIS could have been prepared without including this report, because this is their wetland documentation for the property. And what's more, all the agencies use this report for
I'm going to
verifying
object
the boundaries.
to Dr. Cook making or legal argument here, and in fact, stating incorrect facts as part of that. In general, just stepping back, I need very basically to know what document is being referred to and the page number during testimony, and to have access to that document, and to have had that document and know that it was going to be referred to in advance of today, unless it is a rebuttal document that was necessary as part of a response, which clearly it is not. This is still a case in chief, in order to effectively cross-examine Dr. Cook. I think that is a very, very basic and fundamental requirement of this hearing process. And I would suggest, if this is the only document where we're going to have this issue, perhaps Dr. Cook can find another way to describe the information she wants to convey. But this document was not in the record. And there are many, many other documents in the record, many more up-to-date documents in the record, that perhaps she could use to provide her testimony. And I'm hoping that we're not going to have a number of other documents that we don't know where they are or what they are, and they're not in the record. But with respect to this document, I would object to its submission, because I have not had any opportunity to review it or know that it was
Understood.
going to be part of this testimony.
Understood. There was an extensive pre-hearing document exchange process. It was established that it would be operated that way by the pre-hearing conference, and it's a standard rule. I also understand Dr. Cook's consternation that it was an applicant consultant document. It shouldn't be seen as a surprise. That said, I'm going to repeat my question, which is it possible to proceed with testimony based on documents that are in the record and set aside the issue of whether or not this document should be admitted? Or do we need to halt and address this admission of this document at this time?
This document is mentioned multiple times in the water section of both DEIS.
And again, I'm going to object to
FEIS.
Dr. Cook providing legal argument. This is a legal objection, and she is a witness.
I guess I probably didn't explain clearly, Dr. Cook. When there's an objection, it needs to be decided before you continue speaking. So I really need to hear from Ms. Clungeon at this point. Is it your contention this document needs to be admitted so we can proceed with testimony, or is it possible to proceed with testimony without addressing this, without admitting this document?
I believe Dr. Cook relies on some figures in this document. It is possible that some of the figures and information are located in other documents. We could try and find similar spots.
What I'm going to do at this point, I don't know what I'm going to do at this point. I had hoped that the council would be providing their witnesses the exhibits that were admitted in the record, and that they would be testifying from those exhibits. Mr. Ricklin?
Yeah, may I suggest something? I don't know that it's critical that these documents be admitted as exhibits, certainly not at this stage. I think we can have Dr. Cook testify about her opinions based on her investigation. Some of her investigation involved reviewing documents that are exhibits. Some of her investigation draws on other things that she knows about, exhibits or not. And we can get through the testimony and deal with the exhibit issue later.
That's my preference as well, just in the economy of time. I'm afraid if we spend too much time arguing about this document now, we're not going to get through with the testimony we need to get through today. So I think if it's at all possible, I'd like to proceed without addressing this document. I'd like for the appellant to make a formal motion to submit the document, and we'll have this argument after we've concluded with testimony, if that's possible.
Okay.
And I mean after today's testimony, so it would probably be something we'd take up tomorrow.
Yes, that's fine.
I'm sorry, Dr. Cook. This is frustrating for all of us. I'm sorry that you weren't made aware of what is in the record, but it is expected the witnesses will be testifying to the documents that are in evidence. And so at this point, I'm going to ask that your testimony not need the support of documents that are not in the record.
May I ask a question?
To clarify that, certainly.
Were my comments on the DEIS and the FEIS not submitted to the record? Audrey?
Your comments on the DEIS are part of the record. They are an appendix to the FEIS. So those are part of the record.
And I've also attached to the appeal document.
Yes.
Dr. Cook comment.
Document.
Then this report is in the record then, because I utilized this and I said, these are the documents that I reviewed in my comments. And this was, the Radke reports were part of that.
Understanding that that's the basis upon which you intended it to happen. The document itself was not offered by appellants and it has not been included in the record so far. Your comments are admitted. Your incorporation by reference has not been successful to include this document in the record.
I just think it's because we weren't able to find it in the 10 minutes. I'm virtually positive it is in the record.
And if that's true, that's fine, because then it can be pointed out. If you can proceed without relying on this record that we can't find in this document, we can't find in the record, that would be most efficient.
I can proceed. Okay. Yes.
Well, sorry for this confusion. It's just, it's a formality that needs to be abided by, so.
Okay.
I can proceed then.
I appreciate it. I thank you for your flexibility.
So this figure is shown in multiple reports.
And Ms. Examiner, I'm sorry, I just don't want to beat a dead horse. I thought you just asked the witness to testify in a manner that didn't need the document, and I'm now seeing the document up on the screen.
Yeah, we need to cite figures that are in evidence.
Yes, and this is Scan Exhibit 1, PDF page. It is part of the Scan's Notice of Appeal. It was included along with Dr. Cook's comments.
Thank you, Ms. Clenchen.
So, and just for the record, Dr. Cook's comments are Exhibit 1 to Scan 1.
Yes.
I don't see.
They are included in Scan's Notice of Appeal. They were attached. So it is part of Exhibit 1. It is PDF page. I can't see it. The share screen is blocking it. Here, fine. I'll close this. It is PDF page 28 of Exhibit 1.
Thank you very much. There it is.
So my point on this figure was to talk about surface water flows that currently go from on-site to off-site receiving waters. And what I had wanted to show you, which was blow-ups of this area, because it's hard to see on this, which just would have been easier for you to see this, is that there are wetlands here that through sheet flow are shown to flow into the Snoqualmie River. There are wetlands. There is a ditch system with a culvert in this area right here, which is easier to see on the blow-ups, that show that the site drains from this wetland system, which is wetlands 12 into the Mill Pond site, and that there are wetlands and ditches, wetland 7 in particular in this area, that sheet flow and have direct flow into the Mill Pond site. That was what I was trying to point out. So,
Are you able, Dr. Cook, are you able to see my screen?
Yes.
Okay, is this the correct document that you wanted to?
Yes, this is the correct, this works. It's
Great.
just not as easy to see because it doesn't have the blow ups of the 3 areas.
Well, maybe we can zoom in to some of them, but I just wanted to go through, if for talking about the different wetlands, could you identify where on the sheet they are, just so that we can be clear for the record?
Yeah, oh, my arrow's not showing up. I'm sorry. I was pointing to them on my screen. I apologize. I realize I don't have control. So over in the left-hand corner where you can kind of see wetland, let's see. Here, I can blow it up on my screen. Wetlands 21, 20, and 22. Yes, exactly. Those all sheet flow, and it even says that they sheet flow into the Snoqualmie River offsite. Then in the middle of the project, wetland 12, where there's the loop, the little loop that says wetland 12 continued. If you follow that down to just above where it says the Mill Pond site, there's a little paved road with a culvert underneath it, and that wetland 12 flows underneath the paved road into the Mill Pond site.
Okay.
And then over in the right-hand side, where it says wetland 7, it specifically says wetland 7 continues offsite over in the corner. Keep going down over right where the little green part is. Yeah, right there. It says wetland 7 continues offsite, and it is showing a flow arrow from that wetland to the Mill Pond. So currently there is surface water drainage into the Mill Pond.
Okay.
So my point here was that currently there's surface water flows from the phase 3 area, which into both the Snoqualmie River and Borscht Lake / Mill Pond.
Okay.
So that was, I gotta
Good.
get my documents back because I moved them all around while I was looking for the.
Yeah, we both have a little shuffle there. All right.
All right, so that that was going back to my comment that there is an omission of the Mill Pond Borscht Lake when considering the development of the PCI property. They specifically excluded the Mill Pond Borscht Lake, and I am identifying why that is problematic, given that its hydrologic connectivity to the site, the overall site, the PCI site, and the fact that the agencies themselves and their reports, and those are the reports that I've already pointed out that you've put in the record, have identified the Mill Pond as being integral to an assessment of the entire property with respect to contaminants and water flows. So that's that was my second point. My third point of the 10 that I've identified is the DEIS barely discusses the impacts of disturbing the ground to prepare the site for construction, such as dredging, grading, and digging with respect to the critical areas. And this follows through to the FEIS. So let's see, page 4. The only reference for the activity of ground disturbance as part of the PCI proposed project is on page 3-148 and the top of 3-149 in the DEIS.
The DEIS? Okay,
Yes.
one moment.
And it is a simple mention without any discussion or analysis of potential impacts of that. And I need to point out that the potential for adverse effects on plants and animal life from physical contamination due to both the toxins and the sediments that could incur in surface flows is not discussed at all. And that is something that is almost always discussed in an EIS as the effects of grading on the associated critical areas. And that was not included in the DEIS, and I did not find it mentioned in the FEIS either. So the historical activities that were done to bury the coal ash and soils contaminated with transmission oil are documented, but where this work has occurred is unknown. It's been documented in many of the reports that this kind of activity occurred, particularly both of the DOE site assessments from earlier in the 2000s. But their actual location of where this occurred is unknown. And because the sampling hasn't been done, we can't pinpoint where that happened. And workers from the sawmill reported dredging waste from the pond and bulldozing contaminated sawdust and dirt to fill land on the mill site in areas to create berms. To date, none of these locations are mapped on the known hazards map in the DEIS. And it's crucial that this information be obtained before any ground disturbance. I mean, that's not rocket science. Again, we don't know that information, and it wasn't included in the FEIS. There's a berm along the Mill Pond Road, and this likely has some of the buried contaminants, but again, we don't know because no sampling's been done in that area. This is why the Department of Ecology has been requesting sampling throughout the Mill PCI and Mill Pond Borscht Lake properties. So I can't address what impacts are going to occur because we simply are lacking the data. I can conject as to what may occur, but my main point here is that we are lacking in data in order to do that assessment. And having reviewed EISs since the 1980s and certainly 1990s as a consultant, both for citizens groups and for jurisdictions, I can tell you that this is something that needs to be included, and it has not been included. We cannot make an informed decision because of the lack of data that there is. So, my next point is that the developer has an extensive record of monitoring and reporting violations with the Department of Ecology, and this is in the DIS. My comments from
And Ms. Examiner, I will object to this issue and to the further discussion of this issue. This does not relate to the project or to the adequacy of environmental analysis for the project. These are allegations, which of course there are two perspectives on about past unrelated violations on the property.
I actually have references to these violations.
Again,
documents.
Dr. Cook, again, after there's an objection, there needs to be discussion between the council, and then Sharon Rice is going to rule on it. Sharon, I called myself by my first name, breaking the rule. Then the hearing examiner will rule on it before we continue with your testimony. So Ms. Clengen, well, actually, Mr. Sturbank, are you going to object as well on this topic? And if yes, let's hear both objections before we have council's response.
Yeah, I join in the objection and generally object to the collateral attacks that have been made on, the applicant or the city throughout. They're not a basis for evaluating the legal issues that are before you, which is the adequacy of the environmental analysis. So they're irrelevant as well as lacking in foundation in this particular case.
Ms. Clungeon.
I would respond that this EIS repeatedly makes reference to the processes that will occur later. They reference that MOTCA and cleanup, and basically they haven't done the full analysis, but they'll handle it later. So to the extent that they're relying on MOTCA and cleanup that has to occur under that, I think it's relevant to take a look at, frankly, the history on the site and the contamination and how it's been dealt with in the past, to speak. Yeah, so.
Let me ask, to clarify, are these alleged previous violations related to the subject property, or are they other properties?
They are the subject property.
The alleged violations relate to water quality monitoring for existing businesses that are not part of the proposal. And they relate to alleged grading violations for parking that is not part of the proposal. So the overall gist of this is an attempt to show that the applicant, it is an attack on the applicant's character in an attempt to show that future laws will not be complied with. And I think it's improper. It's certainly, it's just simply improper as part of an EIS review.
Mr. Sturbank, were you adding anything?
Just briefly, the alleged grading violation for parking related to moving bark chips for temporary parking for the Boeing Classic golf event. So the record's clear that we're not talking about grading violations in a paved asphalt parking lot or something like that might be imagined. It was a temporary 4-day event and involved natural materials. And I would join Ms. Kaler's comments. I mean, if the concern is about the adequacy of conditions, then we can certainly talk about condition language, but it's not sort of casting aspersions on character is not relevant to the legal issue in the EIS or even to assuring performance under conditions.
Okay, just for Dr. Cook's note, information, and also to just point out to Ms. Clungeon, the permit hearing included quite a bit of public comment that made similar allegations as to previous violations by or on the property and or by the applicant. I'm going to need you to make a stronger showing that past violations that aren't part of the proposal are relevant to the environmental review before I can allow the testimony.
The violations are related to the extent of contamination, the presence of contamination on the site. If we have a history of violations, that supports the evidence of the contamination and why it's important that we properly understand the contamination on the site. And I believe we have documents with some of those violations that we can provide those as Dr. Cook goes through the testimony.
And are they not in the record?
They are in the record.
This can't be the most important of the issues left to address in Dr. Cook's testimony. Can I suggest or request, please, instead that we move on to the next issue, and then at the end, if strong feelings remain about discussing this, we take this back up. I'm tempted to exclude this testimony, but if we could just move on first and then circle back to the question, I'd appreciate it.
Okay.
The next of my issues was that most of the original delineations done on the PCI property have not, are out of date. And so we need to discuss this. Over the original delineations done on the PCI property for the 48 wetlands were done in 2012. There were two wetlands that were re-verified back in 2015, 16 and 17, when the Army Corps of Engineers verified the wetland boundaries. And that was for wetlands 19 and 25, which were determined to not be jurisdictional, so they are no longer considered wetlands. But the original delineations were the on the ground work was done in 2012. The state and the federal agencies in Washington state, and therefore the best available science in Washington state dictates that this is policy, except a 5-year window from the date of approval by the U.S. Army Corps of Engineers of a wetland delineation. That's their verification date. And the date of the Corps' 2017 verification letter was in March of 2017. So the 5-year window has now expired for all of the delineations on the PCI property. And, this is exacerbated by the fact that the bulk of the work was done in 2012. And anyone who knows wetlands understands that they're not static systems. They fluctuate based on rainfall, groundwater flows, etc. And so their boundaries vary. And so I would point out that we currently are sitting on jurisdictional and boundary determinations that are no longer viable. So I'd like to point that out just because no one else has. That was my fifth comment. My sixth comment is that the wetland ratings that were done as part of the original delineation were performed using a now outdated methodology. And the city's own code under the SMC 19.12.170H requires the use of the new methodology, which came out in 2014. These wetlands have not been re-rated. And the reason that this is important is that the way buffer widths are assigned on wetlands, and that's the area that is to protect a wetland between an area of disturbance and the wetland itself, are established using those wetland ratings. And the old methodology used a scoring system that is incompatible with the city's own code. So you cannot apply the numbers from the wetland rating that was done back in 2012 to be able to score and establish a buffer width using the SMC 1912-170 that's listed in the table as 170-1. Because the scoring is apples and oranges and it can't be used. So all the ratings for the wetlands, in order to calculate how much mitigation is going to be needed and in order to establish buffers for protection on the new development, are all going to need to be redone. And so I needed to point that out too, because that also was not included in the FEIS. And further, by excluding Borsch Lake, it appeared in the FEIS that the city determined that the buffer on Borsch Lake was not going to be applied onto the property, where in fact, code requires that the buffer for offsite wetlands be levied on a property. And so Borsch Lake is a fairly high quality wetland and would likely have a very high wide buffer. But since it's not included and was not discussed as for buffering on the property, that also needs to be part of the record that this needs to be done. If it's a condition of approval or whatever, the buffer for Borsch Lake does need to be levied on the property in terms of where development can occur. And this would be also occur for the Snoqualmie River, which would be, part of that would be in phase 1. So that's the outdated wetland ratings comment that I had. The next of my comments pertains to the discharge of the effluent from wine production that could discharge directly into the Snoqualmie River during flood events. The FEIS noted that comment and said that they would
Objection.
comply with.
Hold on, Dr. Cook. Go ahead, Mr. Sturbank.
I'm just going to interpose an objection, lack of foundation objection to the contention that winery wastewater would be discharged directly into the Snoqualmie River during flood events.
Thank you. I'm going to note your objection and we can address it on cross. Thank you. Go ahead, Dr. Cook.
My comment on that is that the statement in the in response to my comment was that that here, let me. The PCI proposal basically stated that the effluent would be controlled under normal circumstances and that they would comply with all future requirements at the time. Unless a condition, and my statement here is that unless a condition of approval is made, it would be very easy for this issue to be missed once a development is done, so that it should be identified by the city that this needs to be taken care of, and that the effluent, it does indeed follow best available science and best management practices once it's designed. My next issue was the potential impacts of the PCI proposal on site wetlands that are to remain after development were not sufficiently analyzed. I touched on that slightly previously for areas that are both on-site and off-site. I mean, obviously the wetlands that are proposed to be graded out and impacted are not what I'm talking about. I'm talking about wetlands that are slated to remain. There's almost no discussion on how those wetlands are going to be treated if their pre-development hydrology is going to be maintained and that monitoring is going to occur. And this is another one of those things that needs to be identified either by a condition of approval or at this point in time to be sure that this is followed up on, because currently we have no understanding of the hydrologic regime of these individual wetlands, and monitoring needs to occur pre-development and then post-development to be able to track any potential deleterious impacts that occur. And so monitoring needs to commence prior to the development starting. And this would be the growing season before. So this needs to be identified as an issue that's of absolute importance. Again, the FEIS has no information on baseline conditions, and that needs to be identified up front. My next issue was that groundwater was not evaluated sufficiently. I talked earlier about contamination. Probably would have made sense to follow this item right then, but with respect to the wetlands, full groundwater monitoring is absolutely necessary. We currently don't understand what the water regime is in each of those wetlands, and without that information, you cannot make an informed or reasoned decision and to be able to tell if there's going to be impacts post-development. So the groundwater monitoring needs to start before development occurs and continue after the fact in order to make sure that there's no changes to the hydrologic regime unless the remaining wetlands are slated to be enhanced and a different hydrologic regime is recommended. But none of this, I mean, it is preliminary for lots of detail, but to have no detail is not acceptable at this stage of the game. Also, I need to add that the on-site hydrologic regime that would be calculated through the stormwater plan is information that one can use if you know how to develop a modeling for the hydrologic regime in a wetland. But unless that's a requirement by the city, it will not be done. And this could impact the offsite wetlands, both from a groundwater perspective and a surface water perspective. The Snoqualmie River receives both surface flows and groundwater flows currently, and we do not know, no one has tracked what the impacts of the development will be on the groundwater. And both to the Snoqualmie River, which helps, the groundwater helps maintain the base flow of the Snoqualmie River, but also Bourse Lake. So we don't have a handle on what's currently happening or what is projected to happen to groundwater post-development, and that also needs to be done. And last but not least on this one, my last statement is on cumulative impacts as a result of this project. And that does speak a bit to the fact that the phasing has, that's been suggested by the project proponent. There's ample evidence in the scientific literature and through agency requirements, especially through the state and feds, that phasing of a project that is where all the phases are interdependent, especially with respect to impacts on critical areas, which is what I'm covering, is not allowed. You have to include all phases that are interdependent in one overall analysis. Piecemealing, this is what's happened with phase 1, phase 2, and phase 3 is what the Corps calls piecemealing. And it is specifically not allowed because you can't say that you're only going to fill 5-point-something acres in the first phase of a total of 48 wetlands, and then neglect to mention that later on down the line, you're planning on filling another 20 wetlands through the other 2 phases. You need to have a better understanding of what the impacts are going to be to the general ecology of a site. You can't just say, again, nothing exists in isolation. It's all, we need to look at these on the landscape level, and which all the agencies do. And this holds for groundwater. You can't say, oh, well, we're only going to be impacting groundwater on the phase 1 acreage, because that's going to impact the groundwater on the phase 2 and phase 3 acreage, and vice versa. So the cumulative impacts of all 3 phases need to be considered at the same time. And it's not okay that the city has allowed this to be just a phase 1, because the developers fully plans on implementing the 2nd and 3rd phase, and they are going to, over time, add to the impacts of what's being proposed for phase 1. So it's not going to work. It's not going to fly with the other agencies, because having done this now for 36 years, I can tell you that on large projects, it's almost never allowed to piecemeal an overall project such as this, where each of these components is so interdependent on what is going on in the rest of the site. And so that's my comments on the DEIS, and with respect to what carried forward and wasn't changed within the FEIS was basically all those same things. And then with respect to the FEIS, I do have a couple of additional comments on top of the fact that I think I've documented that I think that this proposal, this turning the DEIS into an FEIS was extremely premature. There's insufficient data for most of the aspects that the FEIS examines in order to make those informed decisions. And for having read the comments that were made by various agencies that are all within the record, we can list them now, or you can just accept, just review them yourself, Madam Examiner. No one thinks that this project is ready to go. There's just simply not enough information on this particular site, given its history, and given the fact that despite constant requests for data on not just the contaminants, but groundwater and et cetera, that this was ready to go. So the FEIS didn't address public comments. It didn't address my comments. Most of the comments that were given for my comments or my statements from the DEIS were basically, well, we're not going to impact that, or we're only looking at probable impacts, or trust us, when it comes time, we'll do the right thing because we'll be required to. That's not how the EIS process works. And you can't, how can you make decisions on a development proposal if you don't know what's underneath the ground in a site that's been identified as one of the most toxic in the state? I think over the last yesterday and today, it's been documented that there is a problem with just lack of knowledge of what is going on that site. So let me think there. I have a couple of examples here, which might elucidate why I'm making this statement. So, for example, the FEIS on page 3 states unknown contaminant levels, hydrologically connected draining to and from the PCI site. The FEIS is specifically saying that there are unknown contaminant levels. So if you don't know what the level of contamination is and the direction of groundwater flows, then the contribution to and from the PCI site to, from my perspective, downstream receiving waters and wetlands and streams is unknown. So then how can you say from an EIS perspective that there's not going to be any deleterious impacts resulting from the project? You can't. You can't. Okay, there's a stormwater comment, which I'm not allowed to comment on. And then I will say that with respect to the wetlands, when I mentioned earlier that the stormwater modeling can be used in a way to identify what the hydrologic regime is in the wetlands. For those models, and I've used them extensively over the years because I use them for my own designs, they're based on algorithms that have lots of components to them, each of which has a placeholder for a particular aspect. And those placeholders have average numbers that you can use that basically fit all ecosystems across the United States. But you can take those place markers and actually put in data. So this can be actual amount of impervious surface that you have, or the tree conditions, or the actual soil percolation figures, and not just a placeholder that's, again, an average. And the models get better and more predictive as you are able to replace those components in the algorithm with real data. On this project, we have almost no real data. So, so the modeling that you would use to identify the hydrologic regime for a wetland, because that's what I'm addressing, would be really inaccurate. And unless you could get data on surface water flows, precipitation, groundwater, both shallow and deep, et cetera, and how all those things work through the system, evapotranspiration, which speaks to the soil type and the type of vegetation, you're not gonna get good numbers. And so again, not having the data is really problematic. And let me just check my notes to see if that's, I've already talked about phasing.
And just related to the data piece you mentioned about past requests for data. I know you made clear that you've requested it in your comments, but are you aware, you mentioned other agencies or other requests for data. What was that based on?
There's been multiple requests over the record of the project, actually dating back decades, but certainly from the Department of Ecology. Let's see, I've got references to a bunch of studies where, let's see. Sorry, I've got so many notes here. I'm sorry, I'm not finding it, but certainly in every one of the Department of Ecology assessments, there have been requests for additional data. So this would include in the record, let's see. The let's see, from 1993, the Weyerhaeuser Company, Snoqualmie Facility Class 2 inspection, February 9th and 16th.
Governor, I'm just going to interrupt here briefly.
That
We're
is
going at
figure 7.
Ms. Cook,
Hold
I'm just interrupting here to make an objection. I think we're going outside the scope of this witness's identified testimony. She was supposed to be talking about wetlands. And I believe responses to her own comments was what issue 1A went into. We're now straying outside to responses to other comments, which really was not part of her identified testimony.
In addition to which, the comments, I think the comments that Dr. Cook is referring to, that Ms. Clengen is asking about, are probably comment letters that are attached to the DEIS. And those are in the record, and I can read those for myself. So let's do, and not that she can't make reference to other agencies that ask for information, because that's part of her review of the wetlands on site, but just rather than spend a lot of time digging in to what other agencies ask for comments, let's move on.
And I did mention earlier that I had a discussion with the project manager at the Department of Ecology. Her name is Louise Barty, and she is the boss.
One second. So I'm now, Ms. Kaler.
Nothing to say yet, just getting ready.
I'm anticipating their objection, so I'm interrupting you in advance. I apologize.
Louise Barty is the boss of the woman from Ecology who issued the email that I talked about earlier. I believe the name was Wooten. Kim Wooten. I had a PERSCOM with Louise in 2020, which I have identified in my DEIS comments. And then again in February of this year to find out what the status was, which is how I know that the Department of Ecology has not issued comments on the FEIS yet, to ask, and she directed me to a lot of the documents that are on the city's website, and with respect to the assessment of the toxins on site, because she's the head of, or she's one of the leads of that department. And she has stated that that no additional data had been collected other than the updated AESI.
So I will just generally at this point object to conveying of a substance of a conversation and what a Department of Ecology staffer did or did not say in that conversation.
And so this is an objection based on hearsay?
That would be correct.
And Mr. Sturbank is nodding his head, which means the city joins.
Yes.
I'd like to rule on the hearsay objection, so hopefully deal with it once and for all. And at the outset, Dr. Cook doesn't know this, at the outset of these proceedings, when we understood that this appeal was going to go forward, it was noticed by the city attorney and myself that the city does not have hearing examiner rules of procedure. We had a brief discussion at the pre-hearing conference for this is also for the record, pre-hearing conference regarding whether or not we should try to adopt hearing examiner rules of procedure to address things that are not addressed in the city code. And the party said, we don't have time for that. Let's proceed with the appeal. The code gives the authority to the examiner to establish procedures for this proceeding. Based on the authority that the code does provide me to establish procedures for this proceeding, I will just note for everybody participating that other hearing examiner rules of procedure under which I operate in other jurisdictions address things like admissibility of evidence. They frequently make a statement to the effect of, the strict rules of evidence don't apply in land use hearings, and hearsay can be admitted to the extent that a reasonably intelligent person would rely on it, and it is up to the examiner to decide whether to admit it and whether to grant it appropriate weight and credibility. So, understanding that there's a strong preference that the strict rules of evidence apply in this proceeding, as the person with the authority to decide what procedures apply, I find that they don't. And I'm going to admit this hearsay evidence based on the context of her testimony about it. And hopefully we can reduce hearsay objections going forward. Please trust me to assign appropriate weight and credibility to statements assigned to persons who are not here to be cross-examined. Good?
Thank you.
Ms. Examiner, a brief
Yes.
comment, and I appreciate the clarification. I would just like to make clear that the city was not asking for a strict application of the rules of evidence necessarily. In this particular context, what we are hearing a fair amount of, and I think Ms. Cook said it in a colloquial way, part of the, well, nobody thinks this, or everybody thinks, so we're hearing an effort to bootstrap concerns of certain agencies who are not parties and whose communications are referred to, but then not placed before the examiner. And so in that context, even without applying the rules of evidence strictly, I think reasonable folks in their conduct of their affairs wouldn't rely on the kinds of comments that you are hearing that to the effect of everybody's concerned, in an effort to magnify the appellant's case. And with that, I'll stop. And of course, it depends on the particular statements being made, but I think my comments apply to a lot of what you've heard so far in the hearsay.
Understood. I invite the parties, if you feel it's necessary, to continue to timestamp these objections, to note them for the record, but just generally, please understand, in most cases, I'm going to allow hearsay evidence, and please trust me to assign appropriate weight and credibility. Thank you. Sorry about that giant detour.
Mm-hmm.
But it was going to have to happen sooner or later. So let's proceed. Dr. Cook, you were still testifying. I don't know if you want to return to that topic or move on.
Only in that I took notes during our most recent conversation because it occurred after I had reviewed the FEIS and I had questions about with Ms. Barty that pertained to the fact that I didn't see much additional information given in the FEIS over what the DEIS information that the DEIS had. And she basically stated that they hadn't responded yet to the FEIS because they were vastly understaffed. They didn't know when they would get to it, but that what she knew to date was that she understood from a quick review that she made that she hadn't seen much additional information, but other than that, she had no comments, and that the DOE would respond at a later date. But she did point out a couple of things that I found important, and that was we're not allowed to talk about flooding issues, but something that pertains to the wetlands on the site is that most of the site, in fact, almost the entire site is within the floodplain area. And so once the grading is done, which has not been really discussed much in either the FEIS or the DEIS, the fact that the site floods and you'd be opening up a lot of those, a lot of the area to being flooded, and therefore anything that is in those subsoils to either go as sediment or become part, carried within the floodwaters, that's obviously an issue. And I'm worried again, just with respect to what could happen to the wetlands, which now are contained in little areas and receive surface water flows from areas that have been capped. If the capping is removed and or the area is flooded and areas that are contaminated are now subjected to the floodwaters, the wetlands could have an impact, as could the downstream receiving waters that are receiving that flood water back into it. There could be a problem. And she mentioned that particularly as a concern. Let's see, what else did she say? Here's my notes. She did mention that since the PCI site application was submitted in March of 2017 and was deemed to be complete by the city in April of 2017, little to no data provided as requested by the Department of Ecology in the areas that were identified as early as 1990 and needing cleanup from the years of activity by Weyerhaeuser have been done. The Mill Pond area just to the south of the project, but historically part of the mill site, does overflow into the Snoqualmie River during high volume storm events. And this is not discussed in the DEIS. And so the DEIS is insufficient to identify potential significant adverse environmental impacts.
And again,
This
I'm
is a
going to
statement that she
object
made.
to that last statement, as this is a straying into the area of flooding. This witness is here to talk about wetlands.
Understood. Also, if you're reading from your notes from the conversation of Miss Barty, could you confirm that that's what you're doing?
Yes,
So you're relaying her concerns right now?
yes, I'm relaying her concerns.
And
I asked her what she thought her biggest concerns were. with
Okay,
respect-
and while I'm not generally gonna object to or disallow information just because it's hearsay, it wasn't my intention for that ruling to allow you to convey wholesale a conversation with another agency representative. So I'd kind of like to stop hearing comments from this party at this point. And I think that might take care of Ms. Kaler's objection regarding flooding, because that's where this was going. So again, I am not, some hearsay will be allowed, but there will still be limits as to how much third party and not cross-examinationable evidence will be allowed.
We're done then.
Thank you. Any other questions, Ms. Clengen?
Dr. Cook, did you rely on parts of your conversation with Ms. Barty when you were reaching your own conclusions about the adequacy of the EIS?
No, not really. I had already submitted my comments. I just wanted to find out what the status was of the Department of Ecology's review, and yeah, no, I didn't.
Okay.
All right. And let's see. Okay. All right. I don't have any additional questions. Sarah, did you have any, or Dr. Cook, did you have any additional comments you want to make before we conclude?
No, I think I've touched on all my issues.
Yeah.
Okay.
Okay. Thank you very much.
I appreciate your testimony. Let's go for a cross-examination. We already had a break a little bit before, so let's just dive right in. Ms. Kaler, please go ahead.
Thank you. Initially, I just wanted to confirm, did Ms. Clengen want to offer all of the exhibits that were referenced in that testimony?
Yes, I do.
And let's go over the numbers again, please.
Oh my goodness.
I just wanted to be clear since we've decided to engage in this.
Yes. Okay. All of the exhibits were number one, the notice of appeal, which contained Dr. Cook's comments and some of the diagrams that she relied on. I think there was some, I would out number 2, which is the draft EIS. So I don't think that should be an issue. Exhibit 4, the DOE site hazard assessment, and 4 and
S4, scan 4, scan 5.
Yes, scan 4, scan 5. Also to be, I think there was also reference to site cleanup details. So also maybe scan 6. And then the resume, which was in 18. I believe there was also reference to applicant exhibit M14, was it? The discussion with Kim Wooten. Well, I just want to verify that it was 14.
Yes.
Yes, M14, and then the exhibits to, or the appendices to the various FEIS and DEIS.
I also have in my notes, just for completeness, that Dr. Cook addressed or spoke to or answered questions about S7, S11, S12, and S13, which are the site assessments. So those documents are now offered.
And also, I believe we also exhibit S10, right? Was that included? That was the excerpt from the AESI report.
Yes. You also had some testimony or showed S51. It's a graphic showing fill on site. And so those are now offered. Thank you. Thanks for that, Ms. Kaler.
Thank you. And I guess I would say we have no objection to the omission of those, except that some of them are quite long, older documents relating to cleanup issues. And we would just note that they were, portions of them were discussed, and we would expect they wouldn't show up in the post-hearing briefing for other purposes.
Okay, noted.
Thank you. So with that, good afternoon, Ms. Cook. I'm Courtney Kaler, representing the applicant. It's good to see you again. I have a few questions for you, and I'm just going to go through your testimony in the order that it was given and ask the questions that I have. So first, early on in your testimony, I believe you you refer to the project as one of the most toxic sites in the state. You weren't referring to a list in order of which sites are most toxic in the state, were you right? You were referring to the ranking of the Department of Ecology that you discussed later?
I was referring to a statement that was made in the, let me find it. I was quoting studies that have been done. Part of it came from the ecology's own assessment from the SHA that was done by ecology. And there's also mention in the DEIS of it being a brownfield site. So yes, it comes from a quote from ecology's own reports.
And so that would be the site hazard assessment, either S4 or S5 that you're referring to, exhibits S4 or S5. Those are the two. Those are the two.
It's the ecology SHA site hazard assessment worksheet 1, and then discussions in ecology's sites. Let's see. I'm sorry, I have so many documents here. It's
Ms. Cook, I may be able to help. I'm not actually asking you to find a specific page number, but if you're telling me that the information you're trying to convey is the information that is contained in the Department of Ecology site hazard assessment and not somewhere else, then that's enough information for me.
It's certainly in that assessment. So that's one of many places where that reference comes from. Yes.
And just today, you said one of many, the particular two you've identified, or one you've identified to me as the site hazard assessment and the draft EIS calling this a brownfield site. Are there any other particular references that you can identify here at this moment without
Hold on a second.
taking a very, very long amount of time?
Yeah, I'm trying to do this quickly. Sorry. I may have to get back to you on some of the other areas, other quotes, because as I said, I saw it in referenced in multiple locations.
In order to have you not have to go through that exercise, let me just rephrase. Is your opinion about the site consistent with what's in the site hazard assessment that you referenced? That's in the record.
I can only rely on the other experts, and it was identified as such by other experts from different agencies.
So I don't need you to try and go and sort through other documents. I think you've answered my question.
Okay.
Moving on. In your testimony, you indicated, and this is according to my notes, so let me know if this isn't accurate. With regard to wetland hydrology, you indicated none of the modeling has been done. I don't know if any has been done. Is it your testimony that there has been no hydrologic modeling done?
For the individual wetlands, that is my testimony. I didn't say there wasn't hydrologic modeling done for the surface water plan it's for each individual wetland. It has not been done.
And so do you acknowledge that there has been hydrologic modeling done for the?
I have
and-
seen, yes, I have seen that with respect to a stormwater drainage plan, it has been done, but I also explained that they're two different things.
And is it your testimony that there has been no hydrologic modeling done with regard to wetlands?
Individual wetlands, that's my testimony.
I also heard you refer to the fill of a number of wetlands in planning areas 2 and 3. Is it your belief that the project proposes the fill of wetlands in planning areas 2 and 3?
I didn't say that there was going to be fill. I said that likely there would be fill and that it needed to be considered as cumulative with phase 1.
Is it
There's
your-
been no identified particular areas in either site 2 or 3. The development plan has just some large polygons that I believe we didn't show you the figure, but there is a figure in the FEIS showing just large polygons. So nothing on the ground has been discussed in those phases yet.
And so I will, I guess, ask some follow-up questions. Is it your belief that the project proposes the fill of wetlands in planning area 1?
In as much as there are relatively few wetlands and the on-the-ground design, we actually step back. Yes, it states that 5-point-something acres are planned to be filled in phase of wetlands are planned to be filled in phase 1.
So it is your belief that the project proposes to fill 5.7 acres of wetland in planning area 1?
I didn't say
Is that
7,
right?
it's 5 and change. Yes, that's what the proposal states.
That is your belief. That is your belief that that's
That's my
what's being
belief.
proposed? Okay.
Yes, that's my belief.
Is it your belief that the project proposes to fill any amount of wetland in planning areas 2 and 3?
That hasn't been identified to date. I just said that it would be very hard given the location of the wetlands throughout those areas and what is proposed by the polygons that were shown for there not to be some wetland fill or some impact as a result of loss of drainage or water source.
And so again, just repeating the question, am I correct from that prior answer that, well, you can tell me again, does the project propose to fill wetlands in planning areas 2 and 3? Is it your belief that that is part of the proposal?
It is my belief that that will occur, whether or not it proposes it or not, since there is no identification of what's going to happen in phase 2 and 3 in the FEIS. So my answer is no, there is no proposal for 2 and 3 because this project has been phased and we're only discussing phase 1 in the FEIS.
And just returning to the question of hydrologic modeling of wetlands, is it your belief that no hydrologic modeling has been done with regard to wetland 12?
I would say that I reviewed what had been done, which is more of a stormwater plan and not an individual wetland hydrology assessment as I would do it. So I would say that they said that it was done for wetland 12, but it was done for as a stormwater design, not as a wetland water budget assessment. So those are two different things.
And is it your testimony that no hydrologic modeling was done for wetland 28?
I'm not familiar with wetland 28. I don't remember that from the record.
Okay. I heard you testify, and I believe was admitted to portions of Exhibit M14. I'm just going to go ahead and share my screen so that we can see that. I'm going to try and share my screen. Okay, can you see my screen, Dr. Cook?
Yes, I can, although it's very small.
Okay, here, let me try and increase the size here. I have that issue frequently as well when looking at shared screens. Is it legible at this point in time?
Yes, and I believe, is that the email from Ken Wooten?
I'll just scroll up to the top
Yes,
so you
okay.
can take a look at it. I'm showing you what has been identified as Exhibit M14 and admitted. And you did review a portion of this email, and I just wanted to ask you about a portion of it that you did not discuss. And so I will ask you the sentence that reads, although the timeline for the SHA, Site Hazard Assessment, and EIS review for this site are similar, that's not usually the case. SEPA reviews occur on sites in all stages of the cleanup process, including on sites like this one, where there is still uncertainty on the extent of contamination. Do you see that comment from Ecology?
Yes.
Okay. And so based on that, is it your understanding that SEPA, that the department is conveying to you, or conveying in this email, not to you, but conveying in this email, that the site hazard assessment does not need to precede SEPA review? That'd be a reasonable reading of that sentence.
I think that's reasonable, yes.
And I'm not going to read the whole thing, simply as for a matter of time, we can all read it, but I did just want to highlight one additional sentence. Do you see the sentence that says an approved EIS in no way changes the requirements for site cleanup under MOTCA for either the known areas of contamination or any additional areas of contamination identified in the future?
I do see that.
Okay. And so based on that sentence, is it reasonable to conclude that the requirements of MOTCA for site cleanup will apply regardless of the SEPA action here?
Yes, that's reasonable to expect.
Okay. I'd also just like to turn, since we're looking at emails from Department of Ecology, and I did hear some extensive comments from you earlier on Department of Ecology's opinions. Email that has been identified as Exhibit M15, and I'm trying to get this both large enough so that we can see it and small enough so we can see all of it. Can you read this?
Yes, I can read it.
Okay, great. I wasn't sure if it was big enough here. So this is an email from a Department of Ecology staff person to Lacey Linney, and reflects their conversation. Do you see the statement there that Ecology is not planning on filing an appeal of the final EIS?
I see that, yes.
Okay. And you had some discussion in your testimony that ecology hadn't yet provided comments on the final EIS. Is it your understanding as part of the SEPA process that that there is a opportunity for comment on the final EIS as part of the SEPA process?
Yes, and I also, as I stated earlier, that ecology plans on commenting on the FEIS.
So it's your opinion that as part of the typical SEPA process, there's an opportunity for comment on the final EIS?
I believe I read a statement from Wooten's email that states that they do have the ability to review.
And I'm just asking
to comment.
And I'm just asking your own experience. Do you know? If you don't, that's fine. If there's typically an opportunity for comment as part of on the final EIS, as part of the EIS process?
I have seen projects work both ways in my experience.
Okay.
But I do know that ecology is planning on commenting on the FEIS, at least according to Louise Barty.
And you see here that they're not planning on filing an appeal, and indeed they didn't, right?
Yes, and I asked Louise about that.
Okay.
She stated it's.
And I'm
more
actually not
lack of
asking you
funds.
about your
Stand
conversation with
object.
Louise. At this moment, I'm simply asking you about this email.
Yes, I
All right.
see that.
Great. So then I'd just like to look at this next paragraph. And do you see in this next paragraph that ecology is stating it will continue its role as a regulator and will work with the city and the developer to ensure required permits are attained and appropriate best management practices are included. This process is likely to take some time. Ecology has already had some initial conversations with the city and developer about the contamination and need for a full cleanup under the Model Toxics Control Act. As you saw in the response to comments, the need for cleanup has been acknowledged and cleanup will be integrated as part of the redevelopment. Do you see that?
I do see that.
Okay. And then I'm not going to read the entire thing, but just skipping down a couple lines. To address these concerns, we'll work with the developer and the city to ensure required cleanup actions are taken and the project is permitted under our regulatory authority. Do you see that?
I do.
And so based on this, is it reasonable to conclude that Department of Ecology is informing us through this email that the contamination concerns that have been expressed will be addressed through the regulatory mock-up process under ecology supervision?
I see that they say that they plan on working with the city to address them. I think you're being a little more positive than the statement allows.
It probably speaks for itself.
Mhm.
Thank you. I'd like to move for the admission of M15. And Ms. Examiner, I believe you're muted.
Thank you. Is there, because we're taking an applicant exhibit out of applicant case, let me just ask the parties, is there any objection? Ms. Clungeon, Mr. Sturbank?
No objection from the city.
We'll ask Ms. Clungeon again later.
Oh,
There she
sorry.
is. There you are.
No objection.
Great. I will admit M15 at this time.
Thank you. And Dr. Cook, I may need to share my screen again, but I'm going to stop for the moment so that I can see you and everyone else a little bit better as I go through my notes here. Ms. Cook, you spoke a little bit about exhibit S10, which is the excerpt from the AESI 2015 report. And you mentioned that the depth of testing described in that report went down only, I believe, 2 or 3 feet. Is it your testimony that there has been no soil sampling on this site deeper than 2 feet?
I stated 1 to 2 feet. That's in their report. And I, from the AESI reports from the 2 years, they don't identify going any deeper. If there are other soils reports, which I have not found, then they have not been addressed in either the EIS, DEIS, or the FEIS.
So is it your testimony that you are unaware of any soil sampling deeper than 2 feet on this site?
Other than a few assorted borings in limited locations. I mean, I do acknowledge that those have been identified, but certainly not a systematic a grid pattern that would pick up contamination deep across the site, no.
And so, Dr. Cook, you do acknowledge that there have been soil samples deeper than 2 feet on this site, is that correct?
In very limited locations, yes.
So Dr. Cook, you spoke at length about various potential sources of contamination and particularly wetlands being hydrologically connected, draining to Bourse Lake. Is that a description of the conditions that exist on the site today?
I'm sorry, could you restate the question?
You discussed the potential location of various contaminants and the fact that wetlands currently drain to Bourse Lake. Is that a description of existing conditions?
Yes, that's existing conditions as documented by Radice's drainage map, yes. I can't speak to anything other than what I can find in the record because I have not been on the property.
Okay, thank you. You testified about the omission of Bourse Lake. Is it your testimony that Bourse Lake is not mentioned in the EIS?
No, it's my testimony that it is not included in the PCI proposal.
Ah, thank you. Thanks for that clarification. And Dr. Cook, you're aware that Bourse Lake isn't owned by the same owner as the owner of the PCI plan site, correct?
Yes, it's my understanding.
There was some discussion about, you testified a bit about grading and what information was available with regard to grading. Is it your testimony that there is not a grading plan for this project?
No, my testimony was with respect to the impacts and analysis of potential impacts as a result of that grading plan. There's a lack of analysis of what will occur as a result of the grading plan.
But you do acknowledge there is a grading plan for the property.
You know, it's not something I reviewed, no.
Okay.
It's just something, I was looking specifically for an assessment or an analysis of the impacts of the grading on the critical areas. And that is not included in either the DEIS or the FEIS.
And so as part of your preparation for your testimony today, am I correct that you did not review the grading plan for the project?
not for details of what it would entail, just for an impact assessment.
And I believe I heard you testify about grading out of a wetland. Is it your testimony that is it your understanding that existing wetlands are going to be graded as part of the proposal? Do you know?
If for the wetlands that are projected to be filled or be replaced with development, grading would have to occur.
And can you identify for me which wetlands do you believe are going to be filled as part of the project?
Hold on a second, let me pull up that map. Portions of wetland 12. Wetland 19. Ditch 18. Ditch 2N. Ditch 17. These are all have been considered jurisdictional waters of the US by the Corps, by the way. So for all intents and purposes, they're the same as wetlands. Those look like those are the parts that are in phase 1, although I don't have it superimposed on the phase 1 map.
And so it's your testimony that there will be fill in wetlands 12, 19, 18? Ditch
Well, they'll be
2M?
under buildings.
Okay. And do you happen to have handy the document that you're looking at? Can you tell me what it is?
Toxic waste will wash into the Snoqualmie River. It was the first map I could pull up that showed the planting areas with the underlying wetlands.
I'm just asking, do you know, and maybe you don't, which is fine. If you don't, that's okay. Are you looking at a document that's in the EIS?
Let's see, where is this from? Oh, it was part, it's a document that is part of my DEIS comments.
I see. Okay. Thank you. So let's see here. I'm going to pull up another document, and let me just apologies here if I can take just a couple of moments to locate this. Actually, I don't want to take everybody's time while I scroll through. I'm gonna move on. I may revisit that after I find the correct page. You had some testimony about the age of wetland delineation on the site. Is it your testimony that there has been no wetland delineation field work since 2012?
As I said, Radke went out and revisited a couple of wetlands in 2017, and the Corps revisited a wetland 19 and 25 in 2017, but there is no data sheets available in the Corps report or the Radke update on 2015 for any work having been done other than what I just mentioned.
Okay, so far as you know, that's the extent of your information, and that's what you're basing your testimony on. Is that right?
That's what's in the record. Yes.
Okay. And you also testified that the core delineation has expired, correct?
Yes. As of last month.
Okay. And I also heard you testify, I believe, that the wetland rating methodology was based on 2000, was based on an old code adopted prior to 2014. Is that correct?
A methodology from 2004 through 2008. Yes.
Okay. So I do want to direct you to a couple documents here. So initially, let me share my screen. Can you see this document on my screen now? And I can expand the font if I ask you to read any of it.
It's okay. I can expand it here. What is this document?
So I am showing you what has been identified as Exhibit C2. This is the Draft EIS Appendix C. And I just wanted to ask you a couple of questions about this document. If I can find the correct location. Yes, so I am looking at PDF page 16 of Exhibit C2, the Appendix C. And on the middle of my screen is a paragraph that begins on June 15, 2017. And do you see that paragraph describes reconnaissance work done by Radke in 2017 and 2018?
Yes, I do.
Includes work on a variety of areas on the site, including examination of wetland buffers.
I see that, and I'm familiar with it.
Okay. And looking, then turning to page 19. No, I think I have the wrong page number, so I'm gonna not ask you this question. You testified regarding the discharge of wine effluent, the effluent from wine production. Is it your belief that the effluent from wine production will be contained in a surface pond on the site?
I did not discuss anything that had to do with stormwater design because I was not allowed to. So no, I have not made any comments about where effluent's going to be stored.
Apologies, yes, we did skip that one. Let's do that question. In your discussion of interdependency, you indicated you made some statements about what the Corps of Engineers would do or think with regard to the fill of 5.7 acres in phase one and then subsequent fill in subsequent phases. If indeed no wetland fill is proposed in phase one, would the Corps of Engineers need to issue a section 404 permit for that phase?
It would depend on whether or not there were, there's two different things that go on that kick in a core review. One is stated impacts that are deliberate fill, and the other is indirect impacts as a result of redirecting surface flows, compacting fill so that groundwater is no longer available. And that usually is not kicked in as easily because the Corps often looks, if you're filing a joint aquatic resources permit application, that's when the developer themselves is declaring that they're going to make impacts. Occasionally.
And so my question is, if there are no impacts, if there is no fill to regulated wetlands, would the Corps be involved in the permitting at that point?
That's what I'm trying to explain. There's a difference between a stated impact by a developer, which would kick in automatically 404 if it was above a certain threshold, versus indirect impacts, which could be reported by other jurisdictions or groups that would lead the Corps to believe there were going to be impacts. So
this 5.7 acres of impact that you believe will occur, are you believing that that's going to be fill, wetland fill? I thought I heard you testify to that earlier.
I didn't say fill, I said impacts. So I'm looking at the phase one now, and the development is sitting over portions of wetland 12, as I stated before. Hold on, let me pull up need the wetland map again. Here we go. So phase one is sitting over portions of